We'll hear arguments in number 73, 1766, United States of America against Nixon. And the cross petition, Richard M. Nixon against the United States. Mr. Jaworski, there has been a request for additional time. The court grants that additional time of 1/2 hour, I understand. That's correct?
Correct.
It'll be allowed to each side, and we will not interrupt the argument with any recess. We'll go right through until you're finished. You may proceed whenever you're ready, Mr. Jaworski.
Mr. Chief Justice, and may it please the court. On March 1st last, a United States District Court grand jury sitting here returned an indictment against 7 defendants, charging various offenses, including among them a conspiracy to defraud the United States and also to obstruct justice. John Mitchell, one of the defendants, was a former Attorney General of the United States and also chairman of the committee to re-elect the president. Another, H.R. Haldeman, was the president's chief of staff. Another, John Ehrlichman, was assistant to the president for domestic affairs. The others were either on the president's staff or held responsible positions on the re-election committee. In the course of its deliberations, the grand jury voted unanimously, with 19 members concurring, that the course of events in the formation and continuation of the conspiracy was such that President Nixon, among a number of others, should be identified as an unindicted co-conspirator in the bill of particulars to be filed in connection with the pretrial proceedings. Now, although this particular decision and determination on the part of the grand jury occurred in February, it was a well-kept secret for 2.5 months. The grand jury, of course, knew it. The members of the prosecution staff knew it. It was done so to avoid affecting the proceedings in the House Judiciary Committee. And it was so kept during these 2.5 months until it became necessary to reveal it as a result of the President's motion to quash the subpoena, as I will indicate subsequently in my argument. Now, to obtain additional evidence, which the special prosecutor has good reason to believe is in the possession of and under the control of the President, and which it is believed by the special prosecutor is quite important to the development of the government's proof at the trial in United States versus Mitchell et al. The special prosecutor, on behalf of the United States, moved for a subpoena ducis tecum, and it is the subpoena here in question. The district court ordered the subpoena to issue, returnable on May the 2nd. And the subpoena, of course, called for the production of tape recordings in advance of September the 9th, 1972, which is a trial date. And this was done to allow time for litigation in the event litigation was to ensue over the production of the tapes, and also for transcription and authentication of any tape recordings that were produced in response to the subpoena. Now, on April the 30th, the President released to the public and submitted to the House Judiciary Committee 1,216 pages of edited transcripts of 43 conversations dealing with Watergate. Portions of 20 of the subpoenaed conversations were included among the 43. Then on May the 1st, the President, by his counsel, filed a special appearance, a formal claim of privilege, and a motion to quash the subpoena. Now, for the United States to conduct a full and appropriate hearing on a motion to quash the subpoena, it became necessary to reveal the grand jury's finding regarding the president. And this was first done by the special prosecutor calling on the Chief of Staff, General Alexander Haig, and the President's counsel, Mr. St. Clair, and advising them of what had occurred 2.5 months prior. And then on the following morning, advising Judge Sirica of what had occurred in camera and pointing out the necessity of this being used in connection with the arguments on the motion to quash because of their relevance and the necessity of these matters being made a part of the proceeding. Now, the special prosecutor joined counsel for the President in urging that the matter be heard in camera, which was done. 3 of the defendants had joined the special prosecutor in moving for the subpoena. All of the defendants, at the time of argument in camera to Judge Sirica, opposed the motion to quash.
I don't see the relevancy of the fact that the grand jury indicted the President as a co-conspirator to the legal issue as to the duty to deliver the pursuant to the subpoena that you are asking for.
The only relevance, Mr. Justice, lies in it being necessary to show under Rule 17C that there is some relevance to the material that we were seeking to subpoena.
Yes, and 17C presupposes a subpoena running against a party, and the President is no party. He's not a defendant in one of these cases.
That's correct, sir, but it was also felt that it would be necessary to show why. In order to prove this conspiracy, and in order to provide all of the links in the conspiracy, it was deemed necessary to show that the President was named as an unindicted co-conspirator, and also that this proves.
I thought that was primarily just for the knowledge, information of the House Judiciary Committee.
No, sir, that is not correct, sir. It became very important, Mr. Justice, for us to have that as a part of the proceeding so that we could use the various links in the testimony so as to show that the conversations were such as to make one admissible as against a co-conspirator.
The grand jury sent it to the House Committee, didn't it?
The grand jury sent nothing of an accusatory nature to the House Committee, no, sir. What the grand jury sent to the House Committee was the evidence that had been accumulated, and it very carefully excised from it anything by way of the grand jury's interpretation or anything along that line, Mr. Justice. Now, in its opinion on order of May 20th, the district court first
still be here, Mr. Jaworski, whether or not the President had been named as an unindicted co-conspirator, but that simply gives you another string to your bow. Isn't that about it?
It's true that it admits some evidence that would otherwise not be admissible.
Right, but even had the President not been named, you would still have subpoenaed at least part of this material.
There's no question about that, yes, sir.
You'd still be here.
That's right, sir.
You're not.
That's right, sir. But in order to present the full picture, and in order to present, that also was a part of it. District Court denied the motion to quash and the motion to expunge. They had also been
Jaworski, no one yet has ever suggested that if you're in a criminal trial, conspiracy trial, and some evidence is offered of an out-of-court statement of someone who's alleged to be a co-conspirator, that it's enough for the prosecution to then show that the grand jury had named him as a co-conspirator.
No.
That never gets you, will never get you
No.
over the...
And we don't so contend.
Well, then, that was the point of your, that was the direction of your...
No, this was in connection, with the subpoenaing of this evidence, Mr. Justice. In other words, this was in connection with showing that we had the right to this evidence.
Well, I understand that.
Yes, sir.
But,
and that was the point.
But you do not suggest that that's all you need to show, is that it?
No, sir.
Or
of course not.
You don't suggest that the grand jury finding is binding on the court, or not?
I do suggest that it makes a prima facie case. And I think under the authorities it so does.
Well, let me understand this, Mr. Jaworski. You don't suggest that your right to this evidence depends upon the President's having been named as an unindicted co-conspirator.
No, sir.
And so for the purposes of our decision, we could lay that fact aside, could we?
What I was really doing in pointing to that...
Well, could we?
Yes. Primarily was in order to show a reason for the grand jury's action. There's also before this court a motion to expunge the act of the grand jury in naming the President as an unindicted co-conspirator. And I was trying to lay before the court the entire situation that warranted that action.
Mr. Jaworski,
yes, sir.
As I understand your brief, you go beyond what you have addressed so far. I think you say that the mere fact that the President was named as an unindicted co-conspirator forecloses his claim of privilege.
Well, we certainly
page 91 of your brief.
We certainly make that as one of the points which I intend to discuss at a later point.
In other words, that reduces him in and of itself to the status of any other person accused of crime.
I don't say that it forecloses. What I think we suggest is that it does present a situation here that should not make the application of executive privilege appropriate. We do say that.
But only prima facie.
Prima facie, that's correct. But when you get to the matter, Mr. Justice Powell, of balancing interests, we do feel that that particular situation is a factor that is important. And this is why we laid stress on it. The court's order, of course, was to deliver to the court the originals of all subpoenaed items, as well as an index and an analysis of those items, together with tape copies of those portions of the subpoena recordings for which transcripts had been released to the public by the President on April the 30th. Now, this case presents for review the action of the lower court. Now, may I, before I get to the jurisdictional points, briefly state what we consider to be a bird's eye view of this case. Now enmeshed in almost 500 pages of briefs, when boiled down, this case really presents one fundamental issue. Who is to be the arbiter of what the Constitution says? Basically, this is not a novel question, although the factual situation involved is, of course, unprecedented. There are corollary questions, to be sure. But in the end, after the rounds have been made, we return to face these glaring facts that I want to briefly review for the final answer. In refusing to produce the evidence sought by subpoena ducis tecum in the criminal trial of 7 defendants, among them former chief aides and devotees, the President invokes the provisions of the Constitution. His counsel's brief is replete with references to the Constitution as justifying his position. And in his public statements, as we all know, the President has embraced the Constitution as offering him support for his refusal to supply the subpoenaed tapes. Now, the President may be right in how he reads the Constitution, but he may also be wrong. And if he is wrong, who is there to tell him so? And if there is no one, then the President, of course, is free to pursue his course of erroneous interpretations. What then becomes of our constitutional form of government? So when counsel for the President in his brief states that this case goes to the heart of our basic constitutional system, we agree. Because in our view, this nation's constitutional form of government is in serious jeopardy if the President, any President, is to say that the Constitution means what he says it does, and that there is no one, not even this Supreme Court, to tell him otherwise.
Mr. Jaworski,
yes,
the President went to a court. He went to the district court with his motion to quash, and then he filed a cross petition here. He's not He's asking the court to say that his position is correct as a matter of law. Is he not?
He's saying his position is correct because he interprets the Constitution that way.
Correct.
This
And
is
he's
what
he's submitting his position to the court and asking us to agree with it. He went first to the district court, and he's petitioned in this court. He's not. He has himself invoked the judicial process, and he is.
Well, that's not entirely correct, Mr. Justice.
Well, didn't he file a motion to quash the subpoenas in
File a
the
motion to
district
quash
court
the
of the United
subpoena.
States?
Sir, he has also taken a position that we have no standing in this court to have this issue heard.
As a matter of law, he's asking he's making that argument to a court.
So that
as a matter of constitutional law, he is correct.
So that, of course, this court could then not pass upon the constitutional question of how he interprets the Constitution if his position were correct that I had.
As a matter of law, if his position is correct,
right,
then
sir.
he is the sole judge.
That's right.
And he's asking this court to agree with that proposition as a matter of constitutional law.
But what I'm saying is, if he is the sole judge, and if he's to be considered the sole judge, and he is an error in his interpretation, then he goes on being an error in his interpretation.
Well, then this court will tell him so. That's what this case is about, isn't it?
Well, that's what I think the case is about, yes, sir.
He's submitting himself to the judicial process in the same sense that you are. Is that not so, Mr. Jaworski?
I can't see
You
it
take
that-
one position and he takes another.
Well, Mr. Chief Justice, in my view, frankly, it is a position where he says the Constitution says this, and nobody is going to tell me what the Constitution says, because up to this point, he says that he and he alone is the proper one to interpret the Constitution. Now, there's no way to escape that, because the briefs definitely point that out time after time.
I think this matter may be one of semantics. Each of you is taking a different position on the basic question, and each of you is submitting for decision to this court.
Well, we start.
Maybe, sir.
We start with a Constitution that does not contain the words executive privilege. Is that right?
That's right, sir.
So why don't we go on from there?
All right, sir. That is a very good beginning point, but of course there are other things that need to be discussed too, and as much as they've been raised.
Perhaps it would further narrow the area if as I take it from your briefs, you do emphasize there is no claim here of typical military secrets or diplomatic secrets or what in the Burr case were referred to as state secrets. None of those things are in this case. Is that right?
That is correct, sir. And we do point to the authorities to show that there is a difference in the situation here. I do think that it's proper, as much as I regret to have to do it, to point that the President's interpretation of what his action should be in this particular set of circumstances is one that really requires judicial intervention, perhaps more so than a normal one would. I think that we realize that there is at stake the matter of the supplying of evidence that relates to, the two former close aides and devotees. I think we're aware of the fact that the President had publicly stated that he believed that these two aides of his, Mr. Haldeman and Mr. Ehrlichman, would come out all right in the end. Added to that the fact that the President has a sensitivity of own involvement is also a matter that calls for the exercise of the question to which Mr. Justice Douglas alluded as one that is somewhat unusual. Turning now to jurisdiction, before the court are the two questions of statutory jurisdiction. The court directed the parties to brief and argue.
Mr. Jaworski, at
Yes,
this
sir.
point, help me over one hurdle. Do you feel that the mandamus case as such is here? I search your petition.
Yes, we do, sir.
I search your petition for certiorari in vain to find even a mention of it. And I wondered, it's a
Well,
technical question, but what is your position that the issues in any event are here?
Yes, sir.
Whether the case is
Yes, sir.
or it's not?
We say it's here not only because of the appeal itself, but also because of the petition for mandamus. Now, we did Mr. Justice discussed that in one of the briefs. Now, it may be that it wasn't originally when we filed the original brief on jurisdiction.
You mentioned it in your second brief on the merits.
Yes.
But not at all in your petition for certiorari.
Well, we did in the, it was in the footnote on page 2 of the petition for writ of certiorari, Mr. Justice. Well, I would think so, but there really is no issue between the parties here on the issue of jurisdiction. I mean, there's no argument as between the parties on it, and while, of course, the parties can't agree on it, I must say that on 3 different bases, the jurisdiction does exist as we see it. Now, I'm not yet getting to the question of the intra-executive matter that has been raised, but I am discussing now the statutory basis of jurisdiction. And but to answer your question directly, sir, this is correct. We are standing upon not only the matter that this is an appeal that properly had been in the Court of Appeals, and for that reason has been moved up here properly under 1254.1. We also say that the court has jurisdiction over the petition and cross-petition under 1254.1 because they present for review all questions raised by the petition, by the President's petition for writ of mandamus. And then we also say that in addition to that, the All Writs Act gives this court jurisdiction to proceed.
Of course, if in a mandamus action, Judge Sirica would be the party respondent, and he's not a party in this case, and he's not represented by counsel here, is he?
As far as I know, he's not. No, sir. In fact, I'm sure he's not.
The mandamus would be Nixon versus Sirica, would it not?
But it was brought up by the President in their petition for mandamus. That's right. That's the way it got into this court. Raises the same questions, actually, that were raised on the matter that we brought up on.
Well, what was the chronology, Mr. Jaworski? The notice of appeal from Judge Sirica's order was the first step taken to get to the Court of Appeals, was it?
That's, I believe, right, sir.
And while that was pending, then I gather the President's petition for mandamus was filed.
Right, sir. Yes.
And then the last step was that you filed the petition to bypass.
Right, sir.
And that petition to bypass applied, I gather, to whatever case was pending in the Court of Appeals.
That's correct, sir.
And at that time, the case pending was both the appeal from Judge Sirica's order,
right, sir,
and the President's petition.
Mandamus. Correct.
Do you feel there are not 2 cases?
No, sir, they raise the same questions.
Yet you could bring each up separately if you so chose.
Could have, sir, yes.
Seems to me there are 2 cases.
But inasmuch as they present the same questions, it occurred to us that it was appropriate to rely upon the jurisdiction as to both of them.
Except I would suggest again that with respect to the mandamus action, one of the parties isn't here in court, represented by counsel. He is the party respondent.
Well, it is... I don't have the record before me, but I must say that and I will not make an outright representation that Judge Sirica is, and that's why I hesitated a few minutes ago, was made a party. After all, it was brought up by the President. But I am advised by a note just passed me by Mr. Lacovara that Judge Sirica is a party to that proceeding.
Who represents him here?
I don't know of anyone representing him here, Mr. Justice.
Has he filed any brief or made an appearance at all in any sense?
So far as I know, not.
All right. Well, if you're right, that in any event, Judge Sirica's order was an appealable order.
That's correct.
If you're correct in that submission, do we ever have to reach any issues raised by the mandamus?
No, we would not. We were pointing out that the jurisdiction rests on a 3-pronged basis.
But the mandamus is not your action.
It's not, no, sir.
And you're not obliged to defend it.
That's correct, sir. We, however, were pointing out that the same issues really were raised by it if the petition is properly before the court. Now, if there are no further questions on the matter of statutory jurisdiction, I would like to pass to the intra-executive dispute. First, we recognize, of course, that jurisdiction cannot be waived, and nothing that is presented here is with the idea of suggesting even remotely that there is any waiver with respect to the questions of jurisdiction. But we do say that the contention that there is an intra-executive dispute and that for that reason this court cannot pass upon these questions is not sound. And before discussing the cases, however, I think that it would be appropriate for us to undertake to place this in the right perspective. Let me say first that we stand upon two bases. First, that the orders that were entered creating the office of the special prosecutor and delineating his authority, even the original order at the time that my predecessor was acting as special prosecutor, had the force and effect of law. We also point to the fact that the arrangement made itself with the acting Attorney General that I made, if I may point to it, and one reason I have no reticence in discussing the facts is because the facts are undisputed. There's been no dispute raised as to just what actually transpired. The situation is one of the arrangement itself, which the acting Attorney General points to with respect to the matter of independence having been discussed by him with the President, thus meaning that the President himself had approved the setting up of this particular office and the rights and the responsibilities that it has under the Charter. Now we set this out in the appendix, of course, pointing precisely to what the authority and the responsibilities and the obligations of the special prosecutors are. One of the express duties that's delegated to the special prosecutor is that he shall have full authority for investigating and prosecuting, among others, allegations involving the President, and the delegation of authority expressly states, in particular, the special prosecutor shall have full authority to determine whether or not to contest the assertion of executive privilege or any other testimonial privilege. Now, in the instance of my appointment, unlike the appointment that had been made prior thereto, there was an amended order, and it referred to assurances given by the President to the Attorney General that the President will not exercise his constitutional powers to effect the discharge of the special prosecutor or to limit the independence that he's hereby given, and that he will not be removed from his duties except for extraordinary improprieties on his part and without the President's first consulting the majority and the minority leaders and the chairman and ranking minority members of the Judiciary Committees of the Senate and House of Representatives, and ascertaining that their consensus is in accord with the proposed action. And then that the jurisdiction of the special prosecutor will not be limited without the President's first consulting with such members of Congress and ascertaining that their consensus is in accord with his proposed action. Now, at the time...
It's not important. What does consensus mean? Unanimous? Or...
No, sir. It had been interpreted by the acting Attorney General in conversation as meaning 6 of 8.
I take it when you make reference to this, you are in effect suggesting that your position is certainly different than if a United States attorney were prosecuting this case.
That's correct, sir. I think we have what might be termed a quasi-independent status, where there were delegated to this particular office the performance of certain functions, and there's no reason why the President couldn't have delegated those to us. As a matter of fact, when...
Mr. Jaworski,
yes.
Quasi-independent in the sense of an agency?
Yes, sir. For instance, as a comptroller of currency, he has a status somewhat similar to that, and we know that there are suits brought between the Department of Justice and the comptroller just the other day.
I have trouble with your position being similar to the U.S. Attorney because the U.S. Attorney is absolutely under the thumb of the Attorney General.
Well, I didn't say that. What I meant was that we had an independent status that was really different from the status of the United States Attorney.
I'm sorry.
I thought that was the way I answered the question. Now, I should say that it's interesting when the case of Nixon versus Sirica was before the Court of Appeals. Professor Charles Allen Wright, who was then arguing that case, and who was not on the original brief, but I observe is on the reply brief filed on behalf of the President, at that time argued with respect to the particular office of the Special Prosecutor. Now, in this instance, we have a division of function within the executive in that my friend, Mr. Cox, referring to Archibald Cox, has been given absolute independence. It is for him to decide whom he will seek to indict. It is for him to decide to whom he will give immunity. A decision that ordinarily would be made at the level of the Attorney General, or in an important enough case, at the level of the President. But the President's present counsel, in his motion to quash, as he does here, except the words used are different, but the effect is the same, is contending to the court that the President has the right to determine who, when, and with what information individuals shall be prosecuted.
Nixon against Sirica was different in that the parties there were the grand jury on the one hand, represented to be sure by the special prosecutor, but the grand jury, which is an adjunct of the judicial branch of government on the one hand, and the chief executive on the other. And here, now that an indictment has been returned, the two parties are both members of the executive branch. Isn't that not correct, that there is that difference?
Yes, but the independent, yes, sir, that is correct, but I don't think it's a distinction as to the substance,
Well, you are a member, you're the United States, people of the United States whom you represent. You are not a member of the judicial branch, unlike the grand jury in Nixon against Sirica. You're a member of the executive branch of government, are you not?
That's correct, sir, yes.
And there is that difference.
There's that difference, yes, but I don't think that the description to which I pointed as to the independent status of the independent executor would be any different in the Sirica case as it would be in this case. And I was merely...
No, you're, if anything, more independent than Mr. Cox was under the regulations.
That's correct, sir.
But that doesn't really go to the question that I raised.
Yes, sir. I realize that. Now, may I, however, indicate very briefly, and I know this is an important question, but I do feel that the facts ought to be before the court in detail, indicate just what did transpire with respect to how these particular regulations, this order, was interpreted by the President's acting Attorney General, and also by the Attorney General designate, and also by the President himself, and by the President's Chief of Staff, General Hay. Mr. Bork, in hearings at a time when Congress was pressing the bill of an independent special prosecutor, testified that although it is anticipated that Mr. Jaworski will receive cooperation from the White House in getting any evidence he feels he needs to conduct investigations and prosecutions, it is clear and understood on all sides that he has the power to use judicial processes to pursue evidence if disagreement should develop. It was further pointed out...
You're quoting from whom at what time?
Acting Attorney General Bork's testimony in the House.
On what occasion?
After I had been appointed, and in connection with the hearings on the bill to establish an independent prosecutor by congressional act.
Thank you.
Yes. Then he further said, I understand and it is clear to me that Mr. Jaworski can go to court and test out, and these are the important words, and test out any refusal to produce documents on the grounds of confidentiality. And Attorney General Saxby, then a designate, who was also present at the time that this matter was discussed and at the time that I accepted for responsibilities, testified that I had the right to contest an assertion of executive privilege and stated that I can go to court at any time to determine that. Now, the President himself as we point out in our brief, in announcing the appointment of a new independent prosecutor, stated that to the nation that he had no greater interest than to see that the new special prosecutor has the cooperation from the executive branch and the independence that he needs to bring about that conclusion of the Watergate investigation. The President's Chief of Staff, at the time that this appointment was accepted, and at the time that the new regulations were then drafted by the acting Attorney General, had assured me, and this is a part of the record, because a letter was written at the request of Senator Hugh Scott to the White House as a result of discussions that he had with General Haig, in which I sent a copy of the testimony that I had given to the congressional committees to the White House so it would be fully aware of it, and the receipt of it was acknowledged without any change in the testimony. So I had been assured of the right to judicial process by him after he had reviewed the matter with the President and came and told me that I would have the right to take the President to court, and that these were the key words in this arrangement, and that the right would not be questioned. Of course, this independence that was given to the special prosecutor actually was but an echo of public demand. And if I may be permitted to say so, it was the only basis on which, after what had occurred and a predecessor had been discharged, it was the only basis on which that the special prosecutor could have felt that he could come in and serve and undertake to perform these functions. Now, it's important, I think, to observe that counsel for the President, in his brief, by accepting the proposition that the President and the Attorney General can delegate certain executive functions to subordinate officers, implicitly has conceded, so we think, the validity of the regulations delegating prosecutorial powers to the special prosecutor. The regulations specifically provide, as you will notice from the appendix, and we have set them out, that the Attorney General will not countermand or interfere with a special prosecutor's decisions or actions. This is also a part of the Charter. Thus, to argue, as has been done in these briefs, that the separation of powers precludes the courts from entertaining this action because it is the exclusive prerogative of the executive branch, not the judiciary to determine whom to prosecute, on what charges, and with what evidence, we think misses the point. What has evolved from the regulations, in our view, is a prosecutorial force with certain exclusive responsibilities. And this is why I say that to some degree it could be described as a quasi-independent agency. It's not unlike our situation is. The case we alluded to a few minutes ago, decided by the court just a week or so ago. It's not unlike the case of the Secretary of Agriculture versus the United States. This is the first time that there has been an action brought by one member of the executive branch against another official in the executive branch. And we refer to these cases in our briefs in detail. Now, I want to make it clear that the President at no point, of course, delegated to the special prosecutor the exclusive right to pass on the question of executive privilege or any other privilege, attorney and client privilege, or any other testimonial privilege. What we are merely saying is that we have the clear right to test it in this court, and this is on what we stand. Well, because of the passage of time, if I may, I think I should get to other discussions unless there are questions on this particular point. Passing to the merits, we would say that if there is any one principle of law that Marbury and Madison versus Madison decides, is that it is up to the court to say what the law is. And almost to the point of redundance, but necessary because it was a landmark decision, Chief Justice Marshall reasoned, we think with clarity and emphasis, that it is emphatically the province and the duty of the Judicial Department to say what the law is. And this court, of course, through the years, has reaffirmed, consistently applied that rule. It's done it in a number of cases, in Powell versus McCormick, in the Youngstown Steel seizure case, and Doe versus McMillan, and a footnote, I think a very important one, appears in that opinion when Mr. Justice White pointed out that while an inquiry such as involved in the present case, because it involves two coordinate branches of government, must necessarily have separation of power implications, the separation of powers doctrine has not previously prevented this court from reviewing the acts of Congress, even when it is pointed out the executive branch is also involved. Now, there are a number of cases that speak to that. I think one of the cases that perhaps went into greater detail and also points out quite a distinguishing feature is the Gravel case, whereas in the Gravel case the court did hold that it was appropriate to go into certain matters where privilege had been exercised on the part of a senator on behalf of his aide. There are two things that I believe clearly help us in that decision and also other decisions as far as the questions here are involved. One is that the speech or debate clause is in the Constitution, as is the journal clause, is in the Constitution. It's written in there. And this is what was invoked. I don't find anything written in the Constitution, and nothing has been pointed that is a writing in the Constitution that relates to the right of the exercise of executive privilege on the part of the President. Another very important thing that's pointed out in that case is that it did involve an examination into wrongdoing on the part of those who were seeking to invoke the privilege.
Is the term executive privilege an ancient one?
I beg your pardon, sir?
Is the term executive privilege an ancient one?
It has been used over a period of time. How ancient, Mr. Justice Brennan, I'm not in position to say, but certainly it has been one that's been used over the years, but it is not one that I find any basis for in the Constitution.
Are you now arguing that there is no such thing as executive privilege?
No, sir.
I didn't think so.
No, sir. But I said that there had no basis for it in the Constitution.
You think, if anything, it's a common law privilege? Is that your point?
Yes, sir, and that it has been judicially recognized, and appropriately so in a number of cases as we see it. We do not think that it is an appropriate one in this case. But we certainly do not, for a moment, feel that it has any constitutional base.
In Scheuer against Rhodes, I thought we held that there is a common law privilege in the executives dealing at the state level, but that it is a qualified privilege. Is that not so?
Mr. Chief Justice, that is exactly the point. This court has examined a number of situations. And in some situations, as I think was pointed out earlier, where military secrets and such as that were involved, or national secrets of great importance, the court has taken a good close look and has upheld privilege. But
when you say has taken a good close look, without looking at the evidence sometimes, taking a good close look at the claim and the basis of the claim, is that what you mean?
That's what I mean, yes.
But hasn't this court said that it did have constitutional overtones?
It said it had constitutional overtones, and I don't know in what case it may have been used, but
Court of Claims, I think.
Yes, but it certainly has never placed it in the Constitution, so far as I'm aware of, and the President's counsel, who have carefully examined the authorities.
Right.
That was the Kaiser Aluminum and Chemical Corporation case,
Yes.
Court of Claims, and that phrase was used.
It's judicially tailored?
Yes, sir.
Is it your view that there are no inferences to be derived from the doctrine of separation of powers? Are you saying this is purely an evidentiary privilege?
That the privilege as recognized judicially may have been tied into the separation of powers doctrine, we don't deny. What we say is that separation of powers doctrine, in the exercise and the calling for executive privilege, has not been applied in a number of instances involving both Congress and involving also the executive, despite the fact that even in a congressional situation, a speech and debate clause is there. What I am saying is that the separation of powers doctrine, as was pointed to in the Doe versus McMillan case, has not been permitted to stand in the way of this court examining, yet from the standpoint of whether the executive privilege should be permitted or not. This is what I'm saying.
In Reynolds, the court ended up treating the assertion of privilege there as an evidentiary privilege, but it did allude to the fact that there was a constitutional question and said the court wasn't reaching it, as I recall.
On the issue of executive privilege, I should point out here, is a very narrow one. And I think it's important that we bear this in mind. It doesn't involve a very large or broad privilege rights. What it really narrows down to is a somewhat simple but very important issue in the administration of criminal justice, and that is whether the president, in a pending prosecution, can withhold material evidence from the court merely on his assertion that the evidence involves confidential communications, and this is what it really gets down to. We know that sovereign prerogatives to protect the confidentiality necessary to carry out responsibilities in the fields of international relations and national defense are not here involved. And there is no claim of any state secrets or that disclosure will have dire effect on the nation or its people. Actually, I think when we get to weighing and the non-disclosure as against disclosure, and I think when we begin to weigh the balance of interests, it would seem to me that the balance clearly lies in favor of a disclosure in a situation such as the circumstance here. Of course,
certainly would not be true in case that the Fifth Amendment was involved, but that's not present here.
Not present, Mr. Justice Douglas, and there is no question but what the Fifth Amendment is very plainly written out in the Constitution and is invoked as a clear constitutional privilege. I think that it would be of help if I may point out to the court that there is an excellent article that we have alluded to in our briefs by Professor Berger that appears in the Yale Law Journal, which discusses the Aaron Burr case at length and also other cases that have been pointed to since the time of that case. And if I may just say very briefly that he summarizes the situation by saying that the heart of Marshall's opinion was therefore justly summarized by the Court of Appeals in the Nixon-Sirica case and the tapes case that we have talked about. The court was to show respect for the president's reason, but the ultimate decision remained with the court. And we're not suggesting for a moment here that the matter of executive privilege should not be looked into. This is not. It deserves to be tested. It should be tested, and we urge it to be tested. But the ultimate decision is not one of saying that it is absolute, it rests in the Constitution, it doesn't entitle anyone and doesn't authorize anyone, doesn't even authorize this court to look into it. Because if the courts are the ultimate interpreters of the Constitution and can restrain Congress to operate within constitutional bounds, they certainly shouldn't be empowered any less to measure presidential claims of constitutional powers. I wanted briefly to make mention of the question that has been raised by counsel for the president that involves a motion to expunge the finding of the grand jury's action that the president is to be named as an unindicted co-conspirator along with a number of others when the pretrial proceedings are gone into and the bill of particulars is being filed. And I say that the grand jury's finding, painful as it is, I think on the part of the court must be considered as being valid and is sufficient to show prima facie. It is sufficient to show prima facie that the president was involved in the proceedings in the course and in the continuation of the particular conspiracy that was charged.
Well, is that the issue, Mr. Jaworski, or is the issue whether there can be a collateral attack?
That's also another issue. But I merely wanted to point out that I believe that this court would not go into the grand jury's findings, but it's a prima facie matter, and that this court would not go into it for the purpose of determining a matter of that kind.
I thought we had put that issue aside a while ago. I just don't understand what the relevance is to this case.
Well, I have to agree with you. Neither do I see what the relevance is of the matter of saying that there's another argument advanced here, and that is that the president can't be indicted. And I don't know what the relevance of it is in this case either, very frankly, because it isn't before the court. And yet the argument is made, and many pages of briefs are devoted to it.
I'm just wondering, Mr. Jaworski, why you aren't content with just arguing it is irrelevant without taking on the right...
Well, this is why I skipped the argument with respect to the matter of whether he could be indicted or not. But inasmuch as this question has been raised and briefed and a motion exists before the court, I have to agree that it is relevant. But it is a part of the case. That's the only reason I alluded to it. And I have no interest in spending much time on it.
Well, except part of the grounds on which you rest in subpoenaing this material is the fact that the president has himself been named as a co-conspirator, an unindicted one. And that's true, isn't it? That's part, at least, of the grounds upon which you rest in subpoenaing this material. And the response to that is the president cannot constitutionally be named as an unindicted co-conspirator. So to that extent, it's in this case. The question's in this case.
Well, I don't think it's a matter that, very frankly, has any particular basis to it, because I don't see how this court could be asked to substitute its judgment for that of the grand jury.
Well, that's something quite different again, whether or not there was sufficient evidence before the grand jury to justify the grand jury in naming the president. That's quite a different, and as the Chief Justice suggested, a collateral issue.
That's right.
But the issue of whether or not the president can constitutionally be named by a grand jury as a co-conspirator, even though an unindicted one, is at least tangentially before us, because it's the fact that he has been named by the grand jury that is part of the grounds and part of the foundation upon which you have based your subpoena ducis tecum.
Not only that, I think that it has, to pinpoint it, in our view, a materiality, because it does relate to the question of the proof that we are seeking, the relevance of the proof that we are seeking. Mm-hmm. And this gets into, of course, a discussion of matters that are sealed, in which I cannot discuss with the court.
Right.
But whether or not they had the authority, they did. It is a fact that the grand jury did it.
That's correct, sir.
And so it doesn't, I don't see how we have anything to do with whether they had the authority or not. It's a fact. Isn't that true?
That's, I think, correct. Now,
I thought the heart of this case was the rights of defendants in criminal trials.
That is very much...
That may be exculpatory and free them of all liability. I don't know, but
Well, it certainly is in the case. Now, and of course, what you have reference to also, I'm sure, Mr. Justice Douglas, is the Bray and Jenks, the Bray opinion, Maryland versus Bray, and the Jenks. And this is a part of the case. However, it happens not to be a part of the appeal, although it is a part of the case. But as far as our position is concerned, it doesn't relate to that. But certainly it's true that this material, as we had pointed out in our communications to the President, may well involve exculpatory matters. And we time and again pointed out we wanted them not simply because we felt that there were matters that needed to be developed in connection with the prosecution, but that they could well contain exculpatory matters.
Well, the Brady question really lurks just in the background, does it not? That is, if you get information, whatever you get,
will be available.
You would concede is available to any defendant.
That's right, Mr.
Who can
Chief
make
Justice.
a showing.
That's correct, sir.
And the question of whether or not the defendants under the Brady Doctrine are entitled to subpoena information and material that's not now in your possession but is in the possession of the President was an issue that was left undecided by the district court.
That's correct, sir.
Am
It's
I
not
right about
before
that?
this court.
Right.
I believe with the permission of the court, unless there are further questions, I'll reserve the rest of the time for the close.
Mr. St. Clair?
Mr. Chief Justice and members of the court, my learned brother has approached this case, I think, in a traditional point of view, namely, this is an attempt by a special prosecutor to obtain what he thinks is desirable evidence in a criminal prosecution that he has the responsibility for. Not once, however, have I heard him mention what I think is really involved, at least in significant part, and that is the co-pendency of impeachment proceedings before the House of Representatives and the realistic fusion that has taken place with respect to these two proceedings and the promise of continued fusion, as I understand my brother's position. May I quote from page 50? I think, sir, they really are. First, by way of factual background.
The sole authority to impeach was in the House. And
That's correct.
authority to try was in the Senate.
Right. And the court shall not be used to implement or aid that process, which is what is happening in this case. This case wouldn't be here on July the 8th.
Just how is this done?
All
How
right.
is this case implemented?
I would like to review some of the facts for you in this regard.
Which are in the record?
Well, yes, my brother has mentioned them to you.
No, but are they in the record, not what he's mentioned?
Yes, yes, sir.
Well, we're just an adjunct of the House Judiciary. This case should be dismissed as improvidently granted, shouldn't it?
Exactly right, sir. Not only that, it makes the case unjusticiable at least. Now,
And the district court's decision stands. Is that what you want?
no, the case should be dismissed, sir.
If we dismiss as improvidently granted, I submit that the district court's opinion, the judgment would stand.
Then I would retract what I said. This case should be dismissed.
Well, the case would be on appeal in the Court of Appeals if we dismiss it.
All right.
Are you now talking about the bypassing of the Court of Appeals?
No, sir. I'm talking about the proceeding before the district court through the Court of Appeals to this court.
Well, but if we dismiss this appeal as improvidently granted, it would go back to the Court of Appeals.
Well, as I say, I think this case should be dismissed, period.
No, really what you mean is that you think that the order of Judge Sirica should
set
be
aside.
vacated and set aside.
That's right,
That's
yes.
quite different from dismissing the case.
I agree.
That's deciding it on the merits.
Yeah.
That's right. That's what I'm trying to get across to this court, perhaps unartfully. This case should be disposed of, be it by vacating the order below or not. But in any event, it is improper in our view that this case should be heard in the context that it is now being heard. We wouldn't be here on July the 8th before a crowded courtroom if it was not recognized generally.
Well, it's a political question here. It's
Exactly
a political
right.
question in the district court.
And therefore, it's a non-justiciable issue in this and in the district court. What has happened in this case is...
Did you argue that to the district judge?
I believe we argued the non-justiciability argument. Yes, sir. I know we did. But if you're...
Your position is that the issuance of a subpoena jus tecum is not a justiciable issue.
In this context at this time, sir, what has happened is this. As you know, on February the 24th, a grand jury secretly named the president, among others, as an unindicted co-conspirator. That fact was not made known. On March the 1st, an indictment was returned against a number of the President's chief aides. Coincident with that, and in an open courtroom, the assistant prosecutor, special prosecutor, handed up to the judge a bag together with a sealed letter requesting that this material be sent over to the House of Representatives. The President took no position regarding that proposal because he considered it to be probably appropriate, under the belief that there was nothing accusatory in that material. Judge Sirica himself reviewed the material, found nothing accusatory, and said it would therefore be quite appropriate to send this material to the House of Representatives, not realizing and not knowing that the special prosecutor had previously obtained a secret charge against the President and others, which was definitely accusatory.
As I understand it, was not among the material that was conveyed to the grand jury. There seems to be, if I'm... At least that's what I understood Mr. Jaworski to tell us this morning.
The material that was turned over was before the grand jury.
Now, just a moment. I understood Mr. Jaworski to tell us this morning, very unambiguously and explicitly, that the fact that the President was named as an unindicted co-conspirator was not conveyed to the grand jury.
It was the grand jury's
to the House of Representatives. To the House of Representatives.
No, it was not. The material was sent to the House of Representatives in the belief that it was non-accusatory in nature. It was simply a recital of fact.
Exactly, and that's what Mr. Jaworski has represented again to us this morning, was the fact of the matter.
But Mr. Jaworski had available to him, unknown to the judge and unknown to counsel for the President, a secret indictment naming the President as a co-conspirator. The accusatory part followed later.
Now, followed in what form?
By a newspaper leak.
Yes, it wasn't sent from the court over to the House.
It didn't have to be. All they had to do was read the newspaper. There can be no question about it. And therefore, I say, this case has to be viewed realistically in the context that it is now being heard.
I'm not sure. Perhaps you can help me. Are you suggesting that there was some duty on the part of the special prosecutor to disclose to the district judge that there was this secret indictment before the judge passed on whether the material should be sent to the House?
I think it would have been quite appropriate because the judge's decision was based on the proposition there was nothing accusatory, that under the circumstances absolute fairness was appropriate and required insofar as the President was concerned. No one could argue that the indictment as a co-conspirator or naming as a co-conspirator does anything but impair the President's position before the House of Representatives. That should, in my judgment, have been made known to the judge. I don't know what he would have done under those circumstances. His decision was based solidly on the proposition there was nothing accusatory in the material. Now, my brother says in his brief that this material he now seeks, of course, will be available to the House committee and will be used to determine whether or not the President should be impeached. So this fusion is going to continue. And under the Constitution as we view it, only the legislature has the right to conduct impeachment proceedings. The courts have been, from the history involved and from the language of the provisions, excluded from that function. And yet the special prosecutor is drawing this court into those proceedings, inevitably and inexorably. No one could stand here and argue with any candor that the decision of this court would have no impact whatsoever on the pending inquiry before the House of Representatives concerning the impeachment of the President.
How far does your point go? Let's assume that a murder took place on the streets of Washington, of which the President happened to be one of the very few eyewitnesses. And somebody was indicted for that murder, and the President was subpoenaed as a witness. Would you say he cannot be subpoenaed now because there's an impeachment inquiry going on, and the courts absolutely have to stop dead in their tracks of doing their ordinary judicial business?
I would not say that. I don't think he could be necessarily subpoenaed. I don't think the President is subject to the process of the court unless he so determines he would give evidence. No. But the murder would have, in this case...
You're saying that the courts, as I understand it, have to stop dead in their tracks from doing their ordinary business in any matter involving, even tangentially, the President of the United States, if, as or when, a committee of the House of Representatives is investigating impeachment.
No, Justice Stewart, I'm not. The subject matter of these two matters is the same subject matter.
Well, here are
Should the President...
7 people have been indicted, 6 of whom remain under indictment. A trial is scheduled for next September 9th.
Right.
The prosecutor is preparing for that trial. He's trying to, under Rule 17 of the Federal Rules of Criminal Procedure, to adduce matters to be used in evidence at that trial. You say that cannot go forward because of some tangential effect, or you say a direct effect, upon some other matter going on in another branch of the government. And how far does
I say it should not go forward at this time at the very least, because the subject matter being inquired of in large measure before the House committee is exactly the same subject matter being involved in this argument.
How do we know?
Namely, should the President produce tapes?
Well, what in these tapes involves the impeachment proceeding?
Pardon?
What in any of these tapes is involved in the impeachment proceeding?
Well, if Your Honor please, the House of Representatives have subpoenaed these and more tapes.
I don't know what's in the tapes. I assume you do.
No, I don't.
You don't know either. Well, how do you know that they're subject to executive privilege?
Well, I do know that there's a preliminary showing that they are conversations between the President and his close aides.
Regardless of what it is?
Regardless of what it is, it may involve a number of subjects.
But does not the special prosecutor claim that the subject matter is the same?
He claims that, but he has no way of showing it. In fact, he says it's only probable or likely. He has no way of showing that they, in fact, involve the subject of Watergate.
His claim is honored, but this court, all that would happen would be the evidence to go to Judge Sirica, who would examine it in camera.
I presume that's so, and it would be made available to the special prosecutor. The special prosecutor says that, of course, this would then become part of the impeachment proceedings, and there we are.
Mr. St. Clair, going back to this murder witness situation, if the President, any President, witnessed an automobile accident and was the sole witness, or a murder, as Mr. Justice Stewart suggested, you're not indicating that his testimony, his evidence, would not be available to the court, but merely that he can't be subpoenaed, but might give it by deposition, as several presidents have.
That is quite correct. That is quite correct.
The testimony of justices of this court has been given in past times by deposition.
Really as a matter of accommodation, not as a matter of assertion of a right of one branch over another. But the point I want to make, Justice Potter, is that the same subject matter is inextricably involved in both proceedings, now proceeding on at the same time. And, the House of Representatives has not sought...
Why are you willing to give up 20-some?
Well, that's a very good question I'd like to answer. The decisions that are made in an impeachment proceeding, Justice Marshall, are essentially political decisions.
Oh, I'm talking about in this case. You say you'll give up 20 of them in this case.
Yes, we will, because they've already been made public.
The tapes or transcriptions?
We are, as soon as a judge approves some method of validating the accuracy of these tapes, they can have the tapes. But you have to understand, a tape is a part of a reel. A reel may cover a dozen conversations. So there's a mechanical problem of trying to validate or be sure that this is correct. But it's only a mechanical problem. But once that's solved, subject to the judge below's approval, they have the availability of that.
Would the tapes that you're willing to release be valuable to the Watergate Committee in Congress?
We think so. That's why we made them.
Well, I thought you said you didn't want them to have anything.
No,
that
sir.
This was merely an evidence, a way of getting stuff over to them, but you're going to give them some.
I say this. I say the President should decide as a political matter what should be made available to the House. That the court ought not to be drawn into that decision. The House takes a different view. The House has subpoenaed something in the neighborhood of 145 tapes, and that's a political decision.
So that the House can get them, the President can get them, and the only people I know who can't get them is the court.
The President has not honored any of the subpoenas other than the first one issued by the House. So that there is a dispute in the House now between the President and the Committee on the Judiciary. It's essentially a political dispute. It's a dispute that this court ought not to be drawn into. And this result of a decision in this case would inexorably result in being brought into it.
You haven't yet persuaded me that we're drawn into it by deciding this case. How are we drawn into the impeachment proceeding? By deciding this case?
The impact of a decision in this case, undeniably, Mr. Justice Brennan, in my view,
well, any number
cannot have, it will not be overlooked.
Any number of decisions of this court has...
but I would think it would be an inappropriate thing to do at this time because there is pending...
Well, that's a different thing. You've been arguing we have absolutely no authority constitutionally to decide this case.
I will argue that in a moment, but I'm arguing now only that you should not. I'm arguing now, sir, only that you should not, because it would involve this court inexorably in a political process which has been determined by the Constitution to be solely the function of the legislative branch. And it cannot be that the impact of the court's decision in this matter, which is one of the principal matters now pending before the House, would be overlooked. It would certainly, as a matter of realistic fact, have a significant impact.
But as I said before, we have the beneficiaries here are 6 defendants who are being tried for criminal charges. And what the President has may free them completely.
Mr. Justice Douglas, it may. The Brady issue, we don't believe, is properly before the court. It has not been briefed by us nor by my brother.
Not decided by the district.
And was not decided by the district court. I would only say this, that in the experience that I've had in connection with cases tried, such as the Stans-Mitchell case in New York, the Chapin case in Washington, the Ehrlichman case now going on, there has never been a claim that the President has not made available appropriate and adequate Brady material. But I don't believe it's before this court at this time. What is before this court is a prosecutor's demand for evidence. And I direct my remarks for a moment to that problem. He says that, in effect, we have no right to be here, that we have delegated the who, the when, and with what issues to him. We have delegated the who and the when, and pursuant to that, he has indicted a number of people, and he has indicted them at such time as he thought appropriate. But even he contends that we did not delegate to him what presidential conversations would be used as evidence. That was reserved, and he concedes that that is the fact, and that's what it's issue here, not when and who is to be indicted, but what presidential communications are going to be used as evidence. And that's what the issue is in this case.
Mr. St. Clair, you left me in a little bit of doubt about this mechanical problem. I think perhaps we diverted you from it. Are you suggesting that on a given tape, which is a real type of thing, having an hour or more of material, or maybe several hours?
Or 2 or 3 days.
2 or 3 days, oh, I see. That the first 3 hours might be the material which has already been transcribed and released. The next 3 or 4 hours might be a conference with the Joint Chiefs of Staff or the Chairman of the Atomic Energy Commission on the program to give underdeveloped nations, for example, aid for peaceful uses of atomic energy. Matters totally irrelevant, but confidential. Is that your argument?
It's my argument and the fact. For example,
and you want some mechanism set up so that these things can be screened out.
They have been screened out in the transcripts. Whatever has been published to the public, we are quite prepared to verify the accuracy of. Now, in the course of those transcripts, there are portions left out.
Have you at any time tendered or proffered a statement that a particular tape from 18 minutes after 11 until 3 o'clock that afternoon, including the lunch hour, included a conference with the Secretary of State, the Secretary of Defense, and someone else having to do with totally unrelated matters. Has that kind of a tender been made to the
No,
court?
we've simply published the portion of that conversation that did not relate to that with the notation that a portion has been left out.
But no explanation of why it's left out.
It was left out because it did not involve presidential action as it related to Watergate or something to that effect. We did not disclose the substance of that left out material.
Is there any particular reason why at least the identity of the conferees could not be made?
There might well be such a reason. My proffer to my brother has been that we will verify the accuracy of the printed transcript. So this 1,240-odd pages of presidential conversations that are available to the public and available to him will be usable in the trial. Now, this may well involve a mechanism approved by the court involving counsel for the defendants to be satisfied, so that they're satisfied that the copy is accurate. But this all has to be expurgated out of a reel of tape that may involve several days' conversation. But it's essentially a mechanical problem.
But in the tapes that they asked for in this subpoena that was taken, which is the only thing before us, has any effort been made to say what, if any, part of that can be released?
Other than the 20 that are already published, no effort has been made as yet, sir.
Why not?
Because, if Your Honor please, we haven't felt that it's been necessary to do so, because we firmly feel that the President has every right to refuse to produce those.
You don't think that a subpoena, these are taken, is sufficient reason for you to try?
Well, we moved to quash.
You just ignored it, didn't you?
No, sir, we didn't. We moved to quash it.
And the difference between ignoring and filing a motion to quash is what? I want his answer. What?
Well, if Your Honor please, we are submitting the matter.
You're submitting the matter to this court.
To this court under a special appearance on behalf of the President.
You're still leaving it up to this court to decide it.
Well, yes, in a sense.
Yes.
In a sense.
No, well, in what sense?
In the sense that this court has an obligation to determine the law. All right? The President also has an obligation to carry out his constitutional function.
For us to decide whether or not executive privilege is available in this case.
Well, probably the question is even more limited than that. Is the executive privilege, which my brother concedes, absolute, or is it only conditional?
I said in this case. Can you make it any narrower than that?
No, sir.
Well, do you agree that that's what's before this court and you're submitting it to this court for decision?
This is being submitted to this court for its guidance and judgment with respect to the law. The President, on the other hand, has his obligations under the Constitution.
Are you submitting it to this court for this court's decision?
As to what the law is, yes.
If that were not so, you would not be here.
I would not be here. Now, my brother says, I have no right to even challenge his right to be here, and I'd like to deal with that for a moment. This is, as we point out in our brief, essentially an executive department matter. Whatever may have been the arrangements between the branches of the executive matter with respect to evidentiary matters, and in fact there were no arrangements regarding evidentiary matters, it is not the function of the court to direct or rule what evidence will be presented to it by the executive and the executive's duty of prosecuting. If this was a United States attorney, this case wouldn't be here, of course. It's here only because certain things were delegated to the special prosecutor. But the special prosecutor was not delegated the right to tell the President what of his conversations are going to be made available as evidence. That was specifically reserved, and the only thing that my brother can do is argue about it, and that's what he's doing right here today.
Now,
therefore,
why wouldn't this case be here if this were a United States attorney? I think I agree with you, but I'd like to ask you.
Well, the United States attorney would be directed.
By whom?
By the President.
Or
the Attorney General at the direction of the President.
Was the one who directed the United States attorney.
Well, by the Attorney General at the direction of the President.
Well, no. In the normal case, the President doesn't know anything about mine-run federal prosecutions. That's fair to say, isn't it?
I think so, but most cases don't involve presidential
And in fact, in mine-run
conversation.
cases, the Attorney General doesn't know much about them.
I think that's so.
But let's just a moment.
With all due respect.
Right. So a United States attorney brings a prosecution, and in the course of that prosecution, he, before trial, subpoenas under Rule 17 of the Federal Rules of Criminal Procedure. He subpoenas material in the custody of the President. So what happens?
The President says to the Attorney General, I'm not going to produce this material.
No, well, it's the United States attorney subpoenaing it under your hypothetical case.
That's right.
And so what happens?
And the President, in my view, the President would instruct the Attorney General to instruct the United States Attorney to withdraw his motion.
And the United States Attorney says, I'm not going to do that because I'm
sworn
to uphold justice. And, well, now, how would you have a new United States Attorney?
Well, I'm being a little facetious.
I'm being serious because
I think that United States Attorney, in all respects, would and should be removed from that case. The executive power of the government is not vested in the United States Attorney. It's vested in one man, and that man is the President of the United States.
By statute, it's vested in the law enforcement is vested in the Attorney General.
Yes, but that statute, which my brother cites in his brief, does not deprive, nor could it deprive, the President of his constitutional authority to be the chief law enforcement officer. He shall take care to see that the laws are enforced. The executive power is vested in him, in one man. And the Attorney General is nothing but a surrogate for the President of the United States.
But I'm afraid your argument would be is a very good one as a matter of political science, and it would be a very fine one as a matter of constitutional and probably statutory law, except hasn't your client dealt himself out of that argument by what's been done in the creation of the special prosecutor?
Perhaps,
as you've just pointed out, the special prosecutor is quite different from a United States attorney.
Right. Perhaps with respect to everything except the President did not delegate to the special prosecutor the right to tell him whether or not his confidential communications should be made available as evidence, so that within the package of executive powers normally represented by the executive department as to who shall be prosecuted, that's been delegated to this gentleman. He's exercised that power. When? He's done that. With what evidence? He's done that, as we'll deal with in a few moments. But not with that portion of the evidence that's available that constitutes presidential confidential communication. That's been specifically reserved. And the special prosecutor cannot, and even if the President did give him that authority, probably could not, as a constitutional matter, delegate that. But in any event, he did not.
Delegate what? He could not.
The right to order the President to give up confidential communications.
Well,
that was not delegated.
Not the unfettered right to get it, but the right to go to court and ask a court to decide whether or not he's entitled to it.
Right, and the President, under no circumstances, gave up any of his defenses with respect to that.
And you're making those defenses
and I'm making them right now.
No
and even if we did agree between us that we would vest this court with jurisdiction simply because of the politics of the situation, this court, by all of its decisions, would not accept the vesting of such jurisdiction.
Well, why not?
Because this court determines its jurisdiction. The parties can't agree that it has it.
Yes, but and if surely you're right, as I say, a lawsuit between the Secretary of Commerce, for example, suing the President over a matter of executive policy, we both agree would be unthinkable. And since any cabinet officer is the creature of the President who appointed him, the answer would be you're fired. If you want to.
If it goes that far.
If it goes that far.
That's right.
But aren't we here met both factually and, I suggest, legally with quite a different situation?
I think not in the terms of separation of powers, if I may. My brother's point of view is he views himself as the United States as distinguished from a member of the executive branch. And in his brief, he invokes the United States as really a fourth entity.
Well,
constitutionally, a special prosecutor with the powers that my brother suggests he has is a constitutional anomaly. we have only 3 branches, not 3 1/3 or 3 1/2 or 4. There's only one executive branch, and the executive power is vested in a president. Now, if for political reasons the president wants to dole out some of those powers, he may so do, and has done in this case. But he cannot vest jurisdiction on a court that otherwise the court would not have, nor should the court accept jurisdiction.
But hasn't your client also inhibited himself from the ultimate sanction that you suggested he could impose with respect to your hypothetical United States attorney, i.e. the sanction of dismissing the special prosecutor?
That is
and
correct.
As a matter of law,
That is
regulations
correct.
that have the force of law.
That is correct. And he has not been dismissed.
And until or unless he is,
Nor is he likely
we
to
have
be.
a case or controversy of a very real kind.
The point is, if I may make it, the only issue here is whether the president gave up his right to protect the confidentiality of his conversations.
Certainly.
No claim is made that he did.
You're a living testimony of the fact that he did not give up his right
And my
to
brother
defend his
concedes.
position in court.
The very fact that the delegation to Mr. Jaworski gave him the right to contest the president's claim of privilege presupposed that the president had a right to assert the privilege, not the right to assert it necessarily with complete finality. That's what we're really arguing about here today, isn't it? Now,
If we get beyond the subject matter situation, now if this were the Nixon against Sirica case, where you didn't have what I think is a dispositive problem in this case, namely the lack of jurisdiction in the judicial branch to determine this intra-executive branch. If we had a grand jury subpoena, as was true in the Nixon against Sirica case, then you have intra-branch, and the court would have a better standing in its responsibility to see the grand juries which are under its jurisdiction to have such evidence as they thought appropriate. But we're well beyond that stage. 17C requires a great, a much more restricted form of evidence. It's got to be relevant and admissible. It's nothing like a grand jury subpoena.
Mr. St. Clair,
Yes, sir.
With reference to your point about whether there are 3 branches or 3 in some fraction, is not the Comptroller General something of an autonomous, fractional, more than a 3rd branch figure?
Well, I don't think that
he
the
is a
Comptroller
creature-
General represents, if Your Honor please, that the basic constitutional structure has been changed.
No,
It
but
may
he-
be that
but
he
he may
has
proceed
executive
without-
and he may have legislative functions.
He may proceed with reference to the executive branch, and I would assume with reference to expenditures of the legislative branch, and without consulting either one of them. Is that not?
I understand. He is created by a legislator. It's very much like a semi-independent agency. In one aspect, he's an agent of the legislature. In the other aspect, he's an agent of the executive. But we don't have any more than legislative, judicial, and executive branches.
But Mr. Jaworski, as I understand it, is claiming that he's somewhat like, not necessarily precisely like, but somewhat like the Comptroller General. That he may make decisions and that Congress cannot recall him short of I believe, a 15-year term for the Comptroller General. And the President, no President can fire the Comptroller General. And I suppose the court could not fire him.
Well, I'm sure the court couldn't. I'm not too clear about the president under the Myers case. I really haven't thought that much of it. It could be that he could be fired, but I think that's really somewhat beside the point, because this issue really turns on an admission that as to the element of the executive power here involved, namely presidential conversations, they weren't delegated. So whatever else may have been delegated, those were not. And this court has no jurisdiction to resolve a dispute as to whether or not they should be given up, because that would involve this court in the prosecution of the case, and the judicial...
Can this court decide what's necessary for a trial of a criminal case?
It can, sir, with respect to third parties, But it should not involve itself with the executive function of prosecuting the case.
My only question was that this is a subpoena ducis tecum that was issued by a judge, right?
Yes, sir.
Slightly judicial.
Entirely judicial.
And that's what's before us.
And that we moved to quash, because
But that's what's before us.
the denial of our motion to quash is one of the issues before us. That's right.
The only thing before us is whether or not the subpoena should issue.
I guess it's about the same thing as whether or not it should be quashed. And I think that
That's
amounts
right.
to the same thing.
So that's not political.
Well, it is not in the context of the proceedings here, but in the context of what is in fact involved in this case, it is, I suggest, political, in the sense that this information being sought, admittedly, will become available then to the House.
What you mean political? Well, I don't see where the House has got anything to do with the point that I'm talking about. You said this is political and not judicial. And I submit it could be judicial because it involves the issue of subpoena.
Well, the question is it a proper issue of a subpoena?
That's right.
Judges make mistakes, as do lawyers, and maybe even presidents, for all I know. But the point I want to make with you, sir, is that this is an executive function, an executive decision, one not delegated.
Well, the executive function is, as I understand your discussion, as to whether he should voluntarily turn them over to the special prosecutor. We are past that stage. We are now at the stage where the prosecutor has asked the court to assist him, and the court has assisted him. Does that not take it a step beyond pure political or executive?
We submit that the court improperly assisted him, that the court has no right to determine what the executive will offer in evidence.
Now you get that. I see.
And this is the function of the president. No one has contended that the president has given up his executive responsibilities under the Constitution, and certainly the prosecution of criminal cases is an executive function.
And that's absolute. Now you're arguing absolute privilege.
Yes, sir.
Absolute executive, even though every day or so you issue other ones.
I beg your pardon?
You turn tapes loose every day or so, don't you?
No, we don't turn them loose every day, but we have turned a number loose in the president's discretion in which he thought was the appropriate thing to do. And that's his determination that governs, we suggest.
And you get ready to turn 20 more tapes loose.
No, these would be repetitious, Your Honor, of what already has been made public.
Well, I thought you said in your brief you would turn 20 loose.
Well, those would be the tapes of 20 conversations already made public.
And you release those tapes.
We'll provide a means whereby their accuracy can be verified. To release a whole reel of tape involving a number of conversations poses a mechanical problem.
You're still saying the absolute privilege to decide what shall be released and what shall not be released is vested in one person, and nobody can question it.
Insofar as it relates to the presidential conversations, that is correct, sir.
But you're now dealing,
That's another issue.
Mr. St. Clair, with the jurisdictional question. And as I further understand it, that argument of yours, at least I got it from the brief, involves at least two separate concepts, and maybe three. One is that this is an intra-branch dispute, and that argument would be equally valid under the analogy you use in your brief if this were a dispute between, let's say, two committees in one of the houses of the Congress, and one committee sued the other for jurisdiction of a particular matter. You suggest, and probably quite correctly, that that would not be a matter for the judiciary to determine. That's one argument, that this is purely an intra-executive branch controversy, as it would be between two congressional committees. This is intra-Article 2 branch. The hypothetical case would be intra-Article 1 branch. That's one argument. And then you have quite a separate argument, it seems to me, i.e. that the president, constitutionally, is the chief prosecutor, since he is the executive, and that it's not for the courts to decide what a prosecutor shall use in prosecuting a criminal case. Now, aren't those two separate arguments? You make both of them under this rubric.
That's correct, sir. I don't know how separate they are, but I certainly make both of them.
It seems to me they're quite separate.
But I'm making both of them, and if they're separate, fine. Now, with respect to...
Well, the second argument would have no relevance at all to your analogy of the legislative branch.
Well, I don't want to mislead the court into thinking that I believe Mr. Jaworski has no right to determine any evidence that he can use.
But ultimately, you tell us that it's constitutionally the president as chief executive, and therefore as constitutionally the chief prosecutor, or whatever the statutes might provide, has unrestricted discretion to determine what evidence he will or will not use in prosecuting a case.
That is correct.
Which is quite a different concept from the other concept. You make them both under the same rubric, as I say, but it seems to me they're quite separate arguments.
And I think they're well-founded in the law.
I know you do, or you wouldn't make them.
Now I'd like to move, if I may, to briefly the suggestion that the issue here is non-justiciable on the grounds other than I've already mentioned, namely the context in which this case unfortunately now finds itself. It seems to us, briefly, that the case is non-justiciable for somewhat more technical reasons. First, this is an issue where someone has to exercise some discretion. There are no real bounds or standards by which that discretion should be exercised, and by traditional standards of this court, where that exists, then this court ought not to take the case. Secondly, it seems to me there is a textual constitutional grant if we assume that the grant of executive power includes the means by which that can be effectively exercised. A second ground. Third, of course, there is the political involvement which I have suggested. Therefore, I suggest quite briefly that even if there is subject matter jurisdiction, the case is non-justiciable for these additional reasons. The standards of Baker and Carr and Powell are not applicable here. There's no individual's rights who are being protected against the onslaught of government. The president is not here as an individual. He's here as a constitutional officer in whom the executive power is vested. There is no philosophy that would support a finding of justiciability on the grounds that we're strengthening the democratic process, as was true in Powell and also to a greater extent in Baker and Carr. If anything, a decision in this case against the president would tend to diminish the democratic process. This president was elected on the theory that he would have all the powers, duties, and responsibilities of any other president. And if it's determined that he doesn't, there is a certain amount of diminution of the political aspect of the case, insofar as the constituents who voted for him are concerned. This president ought not to have any less powers than any other president ought to have. And one of the necessary results, as I view it, of my brother's argument is that because of the circumstances of this case, Richard Nixon is, let's say, an 85% president, not a 100% president. And that can't be constitutionally. The framers of the Constitution had in mind a strong presidency. As we know, they considered a number of alternatives, maybe a presidency consisting of 3 members. All of those suggestions were discarded, and a strong presidency was decided upon, may I say, to the distinct advantage of this country as history has developed. Now, by reason of an action of a grand jury, the special prosecutor suggests that this president has something less than any other president would have. I would only call your attention to the action of the framers in the Constitutional Convention when the issue was raised as to whether or not a president who was under impeachment should be suspended during the pendency of the impeachment proceedings. And the decision was definitely he should not, because the framers envisioned a strong, active president, even in the course of impeachment proceedings. They did not want this country to be led by someone who didn't have those full powers, even if he were then under impeachment. And indeed, this president continues to function as president, as he should, even though there are impeachment inquiries underway.
Mr. St. Clair, if I may interrupt you again, is what you're telling us now directed to your point that this is a non-justiciable political question, or is it directed to your point that that executive privilege is absolute and that the determination of it is to be made?
I think it involves both. It's non-justiciable, if I may, because it does involve the court in a political matter. Now, the mere fact that politics is involved, of course, has not prevented the court from taking action in appropriate cases where individual rights are involved or where the franchise of voters could be strengthened by a decision in the court. I'm suggesting in this case the converse is true. Therefore, the justification between in Baker and Carr and in the Powell case is not available or not applicable here. Furthermore, however, the argument still, in my view, has force with respect to the consequences of the grand jury action in naming him as a co-conspirator, which we suggest they were not qualified to do. The President is not above the law by any means, but the law as to the President has to be applied in a constitutional way which is different than anyone else. Namely, we suggest that he can only be impeached while in office and cannot be indicted until such time as he no longer is in office.
Well, let's assume we accept that proposition. What follows from it?
Well, then the naming of the President by a grand jury as a co-conspirator, if that has the effect of diminishing the President's rights, it's a pro tanto, if I may say, impeachment.
I should think you could run the argument the other way, saying that since the President cannot be indicted, then all that can happen to him is that he can be named as an unindicted co-conspirator.
That could be said, but by the naming him of an unindicted co-conspirator, we suggest, is an intrusion by the grand jury on a function that is solely legislative and not judicial.
Well, a president could be sued, could we, for back taxes or penalties or whatnot?
Well, in questions of immunity, I think individually he could be.
The Constitution speaks of persons, any person.
That's correct. I think the President could be sued for back taxes in his individual capacity. But in terms of his power to effect the responsibilities of his office, to protect the presidency from unwarranted intrusions into the confidentiality of his communications, that's not a personal matter.
It may be, and one of these defendants might be completely exonerated from something in one of those tapes.
As I've suggested, that if that defendant will satisfy a court that there is such a tape and will identify it or even come close to it and persuade a court that that would exonerate him, or there's reason to believe it might, I don't believe we'll have a question. But that's not what my brother here is asking for. He's asking for a set number of tapes, not for Brady purposes, although he throws that in, but he really wants them, he says, for prosecution. And I'd like to review with the court the question of the necessity shown for this, because even on his theory of a qualified privilege, there has to be a showing of some necessity. Now, we should understand, I'm sure the court knows, that all of these individuals here involved have testified before the Senate Select Committee, with the exception, I believe, of Mr. Colson, who now has pled guilty under a plea bargain where he's agreed to cooperate, so the special prosecutor has the full benefit of his testimony. They have testified on one or more occasions before a grand jury. In addition, the President has furnished to the special prosecutor the transcripts and tapes of the critical conversations involved in this alleged conspiracy, and I might review those very briefly with you. Mr. Dean, in his Senate committee testimony, suggested that on September the 15th, the President acknowledged knowledge of a cover-up. He changed that later to testimony that he believed that was so, or it was an inference. But in any event, the President furnished that portion of that tape of the conversation with Mr. Dean. Mr. Dean also testified that on March the 13th, 1973, he discussed the cover-up with the President and efforts to blackmail the President by one of the defendants who broke into the Democratic National Headquarters. Later it developed that that was mistaken, that it was actually on March the 21st, and the grand jury indictment proceeds on the theory of March the 21st. The tape of the conversation on March the 13th was furnished. All of the conversations between the principals, being 2 in number, on March the 21st were furnished. The conversation between the individuals and the president on the next day in the afternoon, March the 22nd, was furnished. And a large number of additional conversations were furnished. Now, if Reynolds means anything, and Reynolds, in addition to the Kaiser aluminum case, noted a constitutional question, as I think one of the learned justices suggested, one of the reasons for not facing that issue in that case was it was not necessary, because in the case there was a crash of a bomber that was on a secret mission, and the court said that the parties had the testimony of the witnesses, the survivors, and other testimony, so it wasn't necessary to get to the constitutional question. I suggest that that's true here. It's difficult for me to conceive a prosecutor who has more evidence than this prosecutor has. He has the full benefit of a Senate Select Committee investigation, which staff had 50-odd lawyers, existed for a year. He has the benefit of his own investigation, of a grand jury that sat for 19 months, with an investigative staff of similar proportions. He simply says, I need this because I want to present all of the evidence in the case. He does not say...
You suggest then that even if the prosecutor could get this from a normal third-party witness, he can't get it from the president because of executive privilege, that there must be a further showing beyond the relevance showing of 17C.
Well, as we point out in our brief, a tape of a conversation is very raw material.
Your answer is yes, isn't it?
Yes.
That there is a further showing necessary.
That's right. Does he really need this? What does he say he needs it for?
But how does a district court go about deciding a question like that in advance of trial, unless the prosecutor lays out his entire evidence and says, it's my judgment that this is evidence. Without this evidence, I might lose the case.
He doesn't say that. He made a showing to the court below. The showing is available to you here.
But you would suggest that he would have to do that.
He has the burden. He has the burden under Reynolds, under Kaiser aluminum, and so forth, to show that he needs it. And what does he say he needs it for? He doesn't say he needs it to obtain conviction.
Well, Mr. Clair, while I've got you interrupted, I want to ask you something else.
Yes, sir.
And it's related to this. No matter how absolute the executive privilege is that you claim on behalf of the president, I assume you're talking about conversations to which the privilege would apply.
Yes.
Now, is it...
We have to make such a showing, and I say that's our only burden.
You wouldn't suggest that every conversation the president has while he's in office would be subject to executive privilege.
No, it has to be a confidential communication.
Well, it has to be in the course of his duties as president.
Yes, but it's president
carrying out his duties as president, under the Constitution.
Yes, sir.
Now, I don't suppose if he was talking with one of his aides, Mr. Holden or Mr. Ehrlichman, about an investment of his out in California or some other place.
Or a tennis game or whatever.
Yes, you wouldn't suggest that...
And my brother doesn't suggest that's what he wants either.
Well, how about conversations about a campaign, about the next campaign? Now, that's hardly
that gets a little closer.
Well, very close
the president is a political office, too.
It isn't very close to executing the laws of the United States, is it? Running a political campaign.
I don't think it's very close, no.
And so
I don't think
conversations about that subject matter.
My brother isn't seeking any such conversation.
Well, I know, but shouldn't the president have to say, at least, even if the privilege is as absolute as you say it is, shouldn't he at least have to say, I believe or assert that the executive privilege applies to this tape because this conversation is in the course of the performance of his duties as president?
Well, as I read some of the cases...
You haven't done that either, have you?
We have not done that. We've simply responded to an assertion that these all relate to Watergate, assuming that to be the fact.
Would you automatically say every conversation about Watergate is in the course of the performance of the duties of the President of the United States?
I would think it would be, yes, sir.
Why is that?
Because he has the duty, A, to enforce the laws, that is to prosecute these cases, and B, he had to take care to see that the laws are enforced, that is to investigate them. And much of this material does relate to the investigation, as 1,200 and some pages of the public transcript fully discloses. But I would be ready to concede, and I don't think it's a difficult problem between us, that the President should show that the circumstances are appropriate for the claim of such a privilege, and I think such language appears in Mink and perhaps even in Reynolds and in Kaiser Aluminum. Simply, it has to be a confidential communication, first of all.
And how about, do you concede, or what is your view of the privilege with respect to whether it reaches factual assertions in a conversation? The difference that was made in the Mink case and in others with respect to opinions and judgments as distinguished from facts.
Of course, Mink, I believe, was a statutory case, well, that was one of the exceptions.
So what is your view? Would you say that if a conversation is merely a recitation of fact, it is still covered by executive privilege?
Yes, it is. If it's confidential and it's between the President and some advisor with respect to him, because otherwise...
That hasn't got much to do with the decision-making process, just pure cold facts.
It might well have to do with the decision-making process if the facts are such as were developed in the course of an investigation with regard to the existence of a obstruction of justice charge, much of which the President was involved in. But the fact against opinion decisions really relate to another situation, as I suggest in the statute. But the conversation that the President has with his advisors, we suggest, is absolutely privileged. It's a discretionary matter that he has to exercise in what he's going to release and not release. And since Marbury and Madison, Mississippi and Johnson, it's been clear that the courts will not direct a president to exercise his discretion in any manner. This is not to say that the courts won't strike down, as in Sawyer, excessive action on the part of the president, or excessive action on the part of the legislature. That has happened a number of times. But it's a far different thing to suggest that the court should undertake to direct the president to exercise his discretion in a certain manner. It's not a ministerial duty by any means. It's a matter of discretion. There are some things he feels he properly should, under the circumstances, make available, and others he shouldn't.
The discretion in that particular instance, one here, involves the relevancy of materials to a criminal trial. And that normally has been a part of the judicial power under Article 3, not the executive power.
I'd like to discuss very briefly Gravel, if I may, for example. I think this raises a very important question. There is, of course, an explicit speech and debate immunity provided in the Constitution. As our brief indicates, the reason for this is quite clear. It's to protect the legislature from unwarranted invasion from the executive and perhaps even the judicial. Does not mean that the executive is not entitled to substantially the same thing by implication. And at least in the civil field, as we've pointed out, the courts have worked out by implication as a necessary ingredient to the function of the duties of the executive an absolute immunity from civil liability for actions taken within the sphere of the official. Spaulding and Vilas, I guess, is the leading case, cited Barr, Mateo, and other cases. If such a matter can be worked out with respect to the executive on civil matters, we suggest there is no reason why, and in fact the court should spell out a similar exemption in criminal matters, especially as they relate to the president himself, because while I said the president is not above the law can only be made applicable to him in a certain way while he is in office. Now, if a junior congressman can commit a crime on the floor of the House as apparently as possible under Gravel and Johnson, is it to be said that the President of the United States has less immunity than a junior congressman? I think not. So that I suggest to you that common sense and proper construction of the Constitution, implying within the grant of executive power all of those necessary ingredients to make it work to be effective, which would include immunity and criminal immunity. The President, we suggest, cannot be indicted, can't even be named as a co-conspirator, because that's an assumption of a legislative function under the Constitution. And therefore we suggest that even if this is criminal, the President is immune from the ordinary criminal process. He's not immune from process. But that process that's available to the President is the process of impeachment, which does not include the function of the judiciary branch. And therefore we say that if, under Gravel, a congressman is entitled to immunity even from criminal conduct for actions taken within the legislative sphere of his conduct, then it would be very hard to support a proposition that the President, as the chief executive of the country, is entitled to less.
Except they didn't put him in the Constitution.
Right, and the reason they didn't, sir, was it was not found to be necessary. They didn't put civil immunity in the Constitution either for the executive branch, and this Court has found, of course, that there is such immunity. I'm sorry, sir. It was a speech and debate clause case, and it even forbade, as I understand the Gravel case, grand jury inquiry into motivations and actions of the senator and his aide.
Because the Constitution said so.
Right, and I suggest the Constitution, by clear implication, provides the same not only for the executive but for the judicial as well, but certainly for the executive.
And if we can't find it in the Constitution, what happens to your argument?
Well, I would suggest you should find it in the Constitution. It need not be explicit. It can well be implied.
The question is, if we can't find it, what happens to your argument?
If you cannot find it.
Yes, sir.
Then, if Your Honor please, that portion of the argument is lost as far as this Court's concerned, I guess.
You haven't lost your other point, which is this Court can set up the same kind of privilege that they've set up in other ones.
That's correct. And we're suggesting that it should in this case. Not necessarily because a great deal is now left to be gained by expunging the grand jury action. My brother is right. The damage has been done, and we think quite improperly so. We think the tactics involved with the prosecutor in seeking to make enlarging the scope of admissible testimony is hardly worth what has been done here, but it's been done. But it seems to me history would be served by granting the relief we have prayed for below, namely to expunge this. Secondly, it seems to me the American people would feel better about the fairness of the issues now pending before the House if this act, which we say was improper and illegal, were expunged. But insofar as the mechanisms of this case are concerned, it destroys or removes a basis upon which they contend they are entitled to these documents. And I'd like to address that for a moment.
We've been asked many times to do that in other cases respecting grand juries. Up to date, I don't think we've ever come anywhere near to it.
And up to date, you've never had a President of the United States named as a co-conspirator either, sir.
That's very true.
And the President of the United States, I don't mean to be facetious about it, but the President of the United States, we suggest, can be proceeded against only by impeachment while in office. And his powers are unabated until such time as he leaves that office. Now, with respect to this suggestion that a grand jury finding is prima facie evidence...
That, of course, never been decided either.
No. This case is unusual in many respects. This suggestion that a grand jury finding is prima facie evidence, and therefore the President has lost whatever privilege he otherwise would have had, isn't borne out by either the facts or the legal issues and principles involved. A grand jury finding is not prima facie evidence. Even if it's mentioned in an opening argument in a criminal trial, there's a grave risk of a mistrial. The cases cited by my brother, particularly the Clark case, are clearly cases which require a showing in court, or in Clark, a showing to the judge that there was prima facie evidence of wrongdoing. You may recall that's a case involving an investigation into a juror, as to whether or not the juror had performed properly, and the juror, it had been shown, had testified falsely in the qualifications that she had never had any business relations with one of the parties, when in fact she had. The court said, well, there's a finding of wrongdoing, and based on that, now I will look into the juror's deliberations to see what she did. But Justice Cardozo made it very clear that if he hadn't been able to make a prima facie showing of wrongdoing by evidence before him, there would have been no cause for letting in the light, as he put it. In the Ewing case and other cases in which are relied on by my brothers are all cases where there was a prima facie showing in a courtroom. Now, a grand jury charge is not prima facie. In the first place, it's only accusatory. It's not even admissible in, nor can it be referred to in a trial. Secondly, it can well involve incompetent evidence, as this court recently decided, and it's totally inappropriate to suggest that a president who otherwise would have a very valuable privilege, and I think I should emphasize the value of this privilege, because it is a valuable privilege. All you have to do is read Justice Reed's decision in Kaiser Aluminum, and he spells it out quite clearly, the importance and value of this privilege. To simply say to have a grand jury make a charge that destroys that privilege is an argument that I don't think can be sustained.
Mr. St. Clair, you have not mentioned in your argument a few moments ago on the question of the absence of any provision for immunity for judges or the presidents. You haven't mentioned the holding of this court in Pearson against Reid, where, as I recall it, the court assumed with a sentence or two that there was absolute privilege for the judiciary, but that the privileges of the executive, in that case, policeman, was qualified. The court had no difficulty in concluding that it did not require an express constitutional provision to spell out an absolute privilege for judges. These were state judges in that case, of course.
Well, if Your Honor, please, I don't believe that simply because the Constitution does not explicitly state the immunity, as it does in the Speech and Debate Clause, should this court hold it does not exist in criminal matters. I would like to make one point with the court, however, because I'm sure the point will be raised concerning Justice Kerner, for example. There's a distinct difference, as we point out in our reply brief as we view it, between a president of the United States, a single individual in whom the entire executive function is vested. A president serves 7 days a week, 24 hours a day, and only he or those under him performing his function can exercise the executive function of our government. Now, if a congressman or a senator or even if a judge
Or a vice president.
Is removed from his duties, matters go on. But a president doesn't have that opportunity to take a vacation. It's vested in one individual, and deliberately so.
This is pretty far afield from the basic question here, which is the testimonial privilege.
We say it's a constitutional privilege.
Not prosecutorial immunity, but for testimonial privilege is what we're dealing with here.
That's correct. I think so. I would want to make the point with you that we think that the privilege we're arguing for is both common law and constitutional.
I understand that.
It's constitutional because it's inherent in the executive power.
I understand your argument, but that.
And it's common law because
matter
it's always
whether or not
existed.
a judge can be prosecuted criminally, or
it has to do with
nothing
questions
to do with
of immunity.
testimonial privilege, does it?
Well, my brothers seem to think it does because they say because of the implications of criminality here, the president has lost something he otherwise would not have had.
I understand. May I, since I've already interrupted you, may I
please do
rail upon your good nature a little more, Mr. St. Clair, to ask you whether it is your claim that any of these materials have to do with what have sometimes been called matters of state, i.e., matters of international relations or national defense. Mr. Jaworski assured us that they did not involve matters of state, but I would like to hear what you have to say about that, because, as you well know, both the commentators and court decisions have made a dichotomy between the privilege that exists with respect to ordinary general confidentiality on the one hand of the executive and matters of state on the other, to which a higher privilege has sometimes been thought to be accorded.
Well, I think if a higher privilege has been accorded, it should not, but in any event, the privilege of confidentiality is not unimportant. However, let me direct myself to your question. The answer to your question is no one knows.
But you
won't know until you listen to these tapes as to what subjects are discussed. My brother can only state that it's probable they relate, at least in part, to whatever he says, Watergate. Or it's likely that it might. And I've had the experience, for example, where circumstances were such that the House committee felt that it was likely that a conversation took place between the Attorney General, Mr. Mitchell, and the President regarding plans for surveillance of the Democratic Party. When you looked at the conversation, it wasn't there at all.
But in this case...
So I have no way of knowing, nor does the prosecutor know, what additional matters may be interwoven into these conversations. One thing is certain.
In believing Mr. St. Clair and understanding, Mr. St. Clair, that in this case, to date, no representation has been made by affidavit or professional representation or otherwise that any of these materials have to do with national defense or international relations.
No, and no representation can be made to the contrary either.
And that would be, therefore, a matter to be, under the existing order, now under review of Judge Sirica, that would be submitted to him later in camera.
If this court finds...
I say under his existing orders.
Yes, that's right.
Right.
And the President, presumably, if he were to comply with that order, would make such a representation in an appropriate case. But the fundamental point is that we believe, for the reasons stated, that the President's right to confidential advice is important, and it's actually fundamental to the proper functioning of his government. And in many instances, I suggest, is even more important than military matters or matters of state, so to speak. Because no matter what the conversation is, of course, it's the thought that it might become public that involves then this chilling effect that we've made reference to in our brief under the First Amendment, but as a practical matter. And I can see it myself. The communications are not free and open because who is to say that it won't be called before a grand jury? And most everyone in the White House has been called before a grand jury, sometimes several times. The FBI has interviewed every secretary that had any knowledge of any aspect of this case. This prosecutor has a plethora of information. He says he wants to try this case with all the evidence. Well, he knows better than that. Nobody tries any case with all the evidence. You'd be buried in minutiae. You select the evidence that you think most appropriate to your case. You don't try it with all the evidence. And this special prosecutor has mountains of information.
Who is to determine how much evidence a prosecutor needs? Only the prosecutor.
That's correct. That's correct. Not the court.
Don't you agree?
And if that evidence constitutes presidential confidential communications, then I suggest, if Your Honor please, the President determines that.
Many cases have been lost because the prosecutor had too much evidence.
Well, I suggest that's probably the fact here. So when my brother says, I don't need this evidence to win these cases, in my opinion, but I need them so I can present all the evidence. I've been trying cases long enough to know, and so has he. That's not what he's really after.
Yeah, I'm trying to you too. But St. Clair, I was just wondering, where do you see the burden here is on the prosecution?
The burden under 17C is clearly on the prosecution. And the burden is clearly on the prosecution on every other aspect.
Right. And now, how much is enough for our phrase you've been kicking around, prima facie?
Well, I suggest whatever was considered by this court in Reynolds to be enough is more than enough in this case. We have the testimony of every individual involved. A number of them have pled guilty. Dean has pled guilty. Colson has pled guilty. Kalmbach has pled guilty, et cetera, all under plea bargains where they are under obligation to fully cooperate. This prosecutor is not, nor does he say at any point that he needs this information to prosecute successfully these cases.
Just to pinpoint another issue, let's assume for the moment that we didn't agree with you on your test of privilege, and let's just assume that the only issue that was left in the case was the 17C issue. Now,
then the president wins, in my view.
well, because
Because the prosecutor cannot show that the evidence he seeks is relevant and admissible. Because of the nature of the circumstance, he doesn't know what's in there.
Well, I suppose there are two parts to the question. One, how much of a showing does he have to make as to what might be on the tape? And secondly, if that matter that he claimed is on the tape, is that relevant and admissible under 17C?
We'd have to know what the matter was, what the issues in the case were, but under Bowman and Ioza, it's not enough to show that it probably is or might be or is likely to be. It must be shown to be relevant and must be shown to be admissible.
But Mr.
And that's why it's not a third-party
Mr. St. Clair, you can't put an impossible task on someone who wants a subpoena against a third-party witness or against anybody else as to showing what is precisely on in some documents, I would suppose.
Well, if you want to utilize a 17C, then I suggest that's what you have to do.
He's never listened to the tapes. He doesn't know precisely what's on them. You would say that he could never subpoena a tape unless he had already gotten it.
As a prosecutor, that's right.
Well,
As a grand jury, that's another matter. If he had sought these under a grand jury subpoena, we would then be directly faced with Nixon against Sirica, which we happen to think was improperly and incorrectly decided. But under 17C, we're dealing with a prosecutor's subpoena. The decided cases make it quite clear there must be a specific showing of relevance and admissibility. Now, if he can't do it because of the nature of the matter, then that's his problem, not mine.
The cases you're talking about are cases where a defendant sought discovery of evidence from or sought material in a prosecutor's file.
Most of those cases are, but there is at least one case, I think it's Grossman, that says the rules are equally applicable to the prosecution. It's cited in one of the footnotes in our brief. But a 17C subpoena is conceptually a subpoena for known information. Conceptually, if the prosecutor is looking for things, he should utilize a grand jury subpoena. In that case, I think in Bowman, they wanted the prosecutor to produce each document he was going to use in the presentation of his case. That's specific. It's obviously relevant and admissible.
So once he gets through with the grand jury, he shouldn't be using a subpoena to develop his case.
That's correct. And certainly not under these circumstances.
Do you think that's the practice in the...
I think it is the practice. I think that the grand jury practice is far greater than perhaps the Constitution has envisioned. It's really used today, frankly, as an effective discovery tool.
May I get back to what seems rather fundamental to me? Let us assume that it had been established that the conversations we're talking about here today did involve a criminal conspiracy. Would you still be asserting an absolute privilege?
Yes, quite clearly. And under the analogy with Gravel that I made.
Right, and as I understand it, the public interest behind that privilege is the preservation of candor in discussions between the President and his closest aides.
Quite clearly so. The simple reason,
right.
Sir.
May I follow that
I'm sorry.
What public interest is there in preserving secrecy with respect to a criminal conspiracy?
The answer, sir, is a criminal conspiracy is criminal only after it's proven to be criminal. And we're not at that point yet.
My question was based on the assumption that it had been established that the conversations did relate to a criminal conspiracy.
That is, the case has been tried and the defendant is found guilty.
Well, it could have been established in various ways. As you've just said, a number of people have already confessed, and these people were participants in some of these conversations.
But the fact that one defendant confessed does not make the other defendant guilty.
Of course. But anyway, your answer is that you would still...
First of all, the answer is yes, even if it is criminal, but more importantly, it is yes, because criminality is something that is not necessarily determined at the time that you must resolve the issue, and that you should not destroy the privilege in the anticipation of a later finding of criminality which may never come to pass. It is quite conceivable that a number of these defendants will be found innocent. And in fact, in theory, they are innocent right now.
But what is the public interest in keeping that secret?
To avail the President, if Your Honor please, of a free and untrammeled source of information and advice without the thought or fear that it may be reviewed at some later time when some grand jury, in this case, or some other reason, suggests there is criminality. For example,
But
it's very important... I'm sorry.
You did release him for the grand jury in this case.
Yes, in the President's discretion, he did that. And it's a discretionary matter. But for example, the simple matter of appointments, if I may, an appointment of a judge. It's very important to the judiciary to have good judges. It's not at all unheard of for lawyers to be asked their opinion about a nominee. Now, if that lawyer wants to be sure that he's going to be protected in giving candid opinions regarding a nominee for the bench, it's absolutely essential that that be protected. Otherwise, you're not going to get candid advice. Now, this isn't a state secret. It isn't national defense. I suggest it's more important, because that judge may sit on that bench for 30 years.
Well, don't you think it would be important if the judge and the President were discussing how they were going to make appointments for money?
I'm sorry, sir, I didn't understand your question.
Don't you think it would be important in a hypothetical case if the about to be appointed judge was making a deal with the President for money?
Absolutely.
But under yours, it couldn't be. In public interest, you couldn't release that.
I would think that that could not be released if it were a confidential communication. If the President did appoint such an individual, the remedy is clear. The remedy is he should be impeached. Let me give you...
How are you going to impeach him if you don't know about it?
Well, if you know about it, then you can state the case. If you don't know about it, you never had it.
You're on the prongs of a dilemma, huh?
No, I don't think so.
If you know the President's doing something wrong, you can impeach him. But the only way you can find out is this way. You can't impeach him, so you don't impeach him. You're losing it someplace wrong.
Well, this is, I think, what was suggested in the Seaboard case, where the court said, well, gee, if that's so, then fraud could be all covered over and so forth. Human experience has not demonstrated that that's a fact. Very few things forever are hidden. Secondly, however, this case is not that case. As I pointed out, there is a plethora of information. This is not a case where there is no information. If anything, there is more than enough.
What you're telling us also could be argued the other way, that there's been a waiver, and neither
that is suggested by my brothers.
Your brother have talked about waiver. I don't suggest that.
My brothers suggested waiver, but this privilege is not like Fifth Amendment privilege or attorney-client privilege, where if you let out one word, you've lost the whole thing. That would defeat the purpose of it. As we point out in our brief, public policy requires as much publicity as the President, in his discretion, determines would be appropriate, and the more information, the better. And if you rule that one utterance constitutes a waiver, you're not going to get it. You're not going to have that thing. This is a discretionary privilege that the Constitution, by implication of necessity, and history has shown, is inherent in the executive function, as indeed it is in other functions. We've cited in our brief similar examples of the legislature insisting upon such a privilege, even against subpoenas from courts, the executive, and the courts themselves.
Mr. Sinclair, you're cutting into your...
I know I am. I do appreciate being reminded of that, and I think I would preserve it, which I think is 10 more minutes.
Mr. Mr. Lacovara.
Thank you, Mr. Chief Justice. If I may, I would like to advert first to procedural questions that Mr. Justice Blackmun and Mr. Justice Stewart have raised about whether the mandamus case is properly here. Mr. Justice, we did in our certiorari petition refer to the fact that we were trying to bring before the court for review before judgment in the Court of Appeals the order of the district court, which we said the President had tried to obtain review of in two ways in two cases in the district court, in the Court of Appeals rather, and we gave the docket numbers of those two cases. And that certiorari petition was filed on the 24th of May, and Judge Sirica, who was the respondent, as Justice Stewart properly notes, in the mandamus case in the Court of Appeals, was served with a copy of the certiorari petition, as he had been served with the mandamus petition, as indeed had all the respondents who were otherwise before the court, the defendants in the United States against Mitchell. On May 28th, in accordance with a motion that was filed in the Court of Appeals, a copy of which I believe is in the files of this court, the Court of Appeals transmitted to this court the records in both of those cases, the appeal and the mandamus cases. Now, Mr. Justice Stewart, with respect to Judge Sirica's appearance here, he is a party before this court, and I believe there's a letter on file with the clerk of this court from Judge Sirica in which he states that he will not appear separately, the United States, through the special prosecutors appearing on behalf of Judge Sirica, as indeed we would have in the Court of Appeals, to uphold his decision enforcing our subpoena. So the case procedurally is properly before the court, both with respect to the appeal and the mandamus proceeding. I'd like to...
Lacovara, I'd like to ask before you get too far up. Let's assume you get by the jurisdictional matters and also the standing question, the intra-executive dispute matter, and we get to the executive privilege, or we get to the merits, so-called. Which end of this case would we normally start at, anyway? The 17C end or the executive privilege end?
Well, I think normally you might start at the 17C end, because that would provide for conceivably for a disposition on non-constitutional grounds if you found that we had not made a sufficient showing to satisfy the ordinary requirements of that rule. So in accordance with the court's normal jurisprudence...
Mr. Lacovara, Judge Sirica found that you had satisfied the requirements.
Absolutely.
Well, what's the scope of our review?
We have made the suggestion that any appellate court reviewing this kind of determination applies a standard of whether the district judge, who was intimately familiar with this indictment, and with the 49-page appendix showing that we submitted in demonstrating why each of these 64 subpoenaed conversations was material, he made the finding that we had clearly demonstrated relevance and an evidentiary nature.
What's our standard of appellate?
And your standard of review should be whether he has abused his discretion.
Clearly erroneous?
Clearly erroneous standard, yes, sir.
What about the standard, though?
I'm sorry.
The basic standard he followed.
What about the basic standard?
I think the parties are in agreement that Bowman Dairy and Iozia, that district court decision, established the basic criteria.
The government is in agreement that the standards of Iozia must be satisfied in this case under 17C.
Well, we have suggested that it's possible that a lower standard can be applied.
That's what I'm asking you. What is your position?
Well, my position would be that when you're talking about a subpoena to a third party as distinguished from an intra-case subpoena between government and defendant, a lower standard of relevancy or materiality...
So the parties are not in agreement at all?
Well, we have suggested that even if the proper standard is applied, that we meet that standard because of the showing that we made that each of these items
You mean a necessity standard?
Necessity in the sense of being relevant to the issues to be tried and being of an evidentiary nature. Now, the necessity standard comes in more in determining whether the executive privilege claim should be overridden if, apart from the waiver fact and what we call the Clark point...
What about Mr. St. Clair's argument that under 17C you can't possibly satisfy its requirements because you don't know what's in the tapes?
Oh, well, that obviously we don't think is a proper legal standard, and the courts have said. In fact, we go back to Chief Justice Marshall's opinion in the Burr case, where exactly the same a suggestion was made by the United States Attorney in opposing the subpoena that Burr hadn't specified which portions of General Wilkinson's letter were really going to be material, and Chief Justice Marshall applied with his eloquent common sense, of course not, because he hasn't seen the letter yet. But he's made a sufficient averment that it does contain something material, that at least it should be brought into court. Now, we have, as I say, gone much further than Colonel Burr did.
Now, you think IOSA just means only evidentiary and relevant? Is that that's your reading?
When you're talking about just a subpoena between the parties, yes, sir. They talk about other criteria, which I think are really subsumed, whether it's a fishing expedition, whether you're going off on a frolic. But as the later cases, as I believe Judge Sirica indicates, seem to have distilled that.
So you don't think IOSA and Bowman requires any showing that this particular evidence be something more than evidentiary and relevant?
That it be critical? No, sir, I don't believe so. I think that, as you were suggesting before, and as Judge Sirica held, it's never been the law that once an indictment is returned, the prosecution is not entitled to continue gathering evidence. The burdens of proof before a grand jury and a trial jury are clearly different. It's an abuse of the grand jury process that has been held to use a grand jury subpoena, as Mr. St. Clair suggested, to continue gathering evidence after an indictment is returned.
Yes, but you apparently concede that you can't use it just for discovery.
Yes, sir.
And you say that the evidence you're seeking by a subpoena, you must make some kind of a minimal showing of admissibility. You can't, for example, seek something that would admittedly be inadmissible hearsay.
Well, I hope I'm not conceding more than I should, but the rule does talk about subpoenaing material from a person on a showing that it will be relevant. It's the Rule 17, and I'm taking a position which is narrower than, of course, you're suggesting, Mr. Justice, that I might take, but in all candor, the rule talks about subpoenaing documents from a person, not only from a party, Mr. Justice Douglas. I believe you earlier mentioned that the rule applied only to subpoenas to parties, but the rule specifically provides for subpoenas to persons who are not parties to the case. But it says, and this was the clause that we were relying on here, the court may direct that the books or papers be produced before the court at a time prior to the trial or prior to the time when they are to be offered in evidence. So there does seem to be some natural focus about the evidentiary nature of the materials.
I get the government's position because it is a rather important part of the case.
Yes, sir. We insist, as Judge Sirica found, that with citation of chapter and verse, if I may, in our 49-page showing before the district court, with references to sworn testimony, as well as with representations about what witnesses will testify at trial, we demonstrated why each of these subpoenaed conversations satisfies the Bowman-Dairy-Iozia Rule 17c standard. Now, that leads me into the related point. What is the relevance of the grand jury's finding that the president was a co-conspirator in this case? It has been alleged that we did this in order to prejudice the president's rights. I think we have sought to demonstrate in our reply brief that that was in no sense...
Mr. Lacovara, I don't think it'd be very hard to understand the relevance of a showing at the trial for purposes of evidence that certain people are co-conspirators.
Yes, sir.
For purposes of introduction of evidence. But that's a little different question than the relevance of the grand jury having come to that conclusion.
Yes. Normally, I will concede, it is not the practice, as anyone who's been a prosecutor knows, for the grand jury, if it is not identifying the co-conspirators in the body of its indictment, to place them on the record. It is fairly common practice, however, for an indictment to say, in addition to the defendants, the named persons are unindicted co-conspirators. This is not an ordinary case.
That may be so, but even if they name it in the indictment, that isn't enough on which to base the introduction of out-of-court statements by an unindicted co-conspirator.
Yes, that was the point that I wanted to get to in discussing what we call our Clark argument. We have never argued, and of course there would be no basis for arguing, that the mere grand jury finding, whether on the face of the indictment or in the grand jury's minutes, that the president or any of the other 18 unindicted co-conspirators were members of this conspiracy, would itself be enough at trial to warrant the judge's admission of extrajudicial statements given by those co-conspirators. We're not making that contention here. The issue arises because a motion to quash a subpoena was filed prior to trial, and the basis for that motion was a claim of executive privilege, a governmental privilege that exists for the benefit of legitimate governmental processes. We countered that apart from Nixon versus Sirica and the balancing process, and apart from the waiver argument that we also develop at some length, this president, as difficult as it was to say this, not because of the evidence, but because of the inherent awkwardness of it, this president is not in a position to claim this public privilege for the reason that a prima facie showing can be made that these conversations were not in pursuance of legitimate governmental processes or the lawful deliberation of the public's business. These conversations, as we showed in our 49-page appendix, and as the grand jury alleged, were in furtherance of a criminal conspiracy to defraud the United States and obstruct justice. We did not rely, even before Judge Sirica, and we do not rely here, merely on the fact that the grand jury made this determination. We do submit that for purposes of a pretrial consideration of a subpoena that is challenged on grounds of executive privilege, we are not confronted with the need that we will be confronted with at trial, and which we fully intend to discharge, of showing by evidence to the trial judge that the president and the other co-conspirators were members of the co-conspirators.
One of your grounds for the non-applicability of the privilege is that these conversations were in the course of the conspiracy.
Yes, sir. And
that you say is satisfied by merely the grand jury?
No, sir. No, absolutely not.
Just a moment.
I'm sorry.
It isn't satisfied merely by the grand jury finding, so a court must go on and make its own determination. If they were going to agree with you on this ground.
Let me back up a little. I see the point that you're making. We are taking the position that the grand jury's determination is conclusive on the court on two issues. A, that a conspiracy existed, and B, that President Nixon was a member of the conspiracy. That is not enough, we concede, to override a claim of executive privilege, because, as Mr. St. Clair well says, he is still the president, and he still is in a position to invoke executive privilege. Where we have said we must bear an evidentiary burden to the satisfaction of the court is on drawing the nexus between the subpoenaed conversations and the conclusively determined prima facie showing that there is a conspiracy of which the president is a member. We made that evidentiary showing to Judge Sirica. That showing is before this court. Judge Sirica found that that showing was sufficient. And for that reason, as I believe his opinion, although it had to be guarded because these items were placed under seal, reflects that he did make the showing.
That showing, or such a showing, could arguably have been made whether or not the grand jury had named the president. Could it not?
Yes, sir. It could have been made as an evidentiary matter.
Exactly.
But we
Don't
are...
you say it was?
Pardon me?
Isn't it your position that it was independently of the naming of the president as an unindicted co-conspirator?
Yes, sir. The evidence that was placed before Judge Sirica, we would submit, would be sufficient to make that showing. And we have said that that is not legally necessary, that we did not have to prove a conspiracy, in effect prove the whole case that may take 3 months to try in order to defeat a claim of executive privilege before trial. This court has frequently said that the criminal process would be burdened down unduly if proceedings were preceded by many proceedings. That's exactly what we have here. We submit the evidence is sufficient. Judge Sirica, the evidence, this is a situation in which the showing that we did submit, intrinsically we submit, tracks the allegations of the indictment and provides independent evidentiary support for those allegations. We have said, though, that it is not legally necessary in a proceeding like this for the court independently to decide whether the grand jury had enough evidence before it to say there is a conspiracy or that a particular individual was a member of the conspiracy. We said all you need to find is that we have shown that these conversations were in furtherance of that conspiracy.
Mr. Lacovara?
Sir.
Let's back up a minute. Do you concede that an incumbent president of the United States could not be indicted and tried for crime?
No, sir.
You do not? You think he could be?
We have not expressed a position on that, Mr. Justice Powell.
Let's assume for the moment that he could not be. Would you still argue that a grand jury had the power or the right, and if so, by virtue of what?
Yes, we argue that.
As an unindicted co-conspirator.
We do, in fact, make that argument at some length. I guess all of our arguments are made with too much length. But we do argue at length, sir, seriously, that the question of presidential indictability, which we offer some views on, just to show that the question is an open one, because of our obligation, we believe, to the law and to the court, is not really determinative of the question that is really in this case, to the extent that the court reaches the expungement argument advanced by counsel, or to the extent that the court does not reach the so-called Clark argument that executive privilege just cannot be invoked here. The issue of presidential indictability does not determine the issue whether an incumbent president can be named as an unindicted co-conspirator by a grand jury. We have shown in our brief why even persons who do have some constitutional immunity, and counsel argues that implicitly under the framework of the Constitution, the president should have an implicit immunity from prosecution. Even such persons can be and frequently are named by grand juries as unindicted co-conspirators. The practical arguments that may militate in favor of a judicial recognition of some unique immunity for the president alone, not for circuit judges, not for Supreme Court justices, not for members of Congress, but the president alone, it may be held at some later date, is immune from prosecution. But that by no means suggests the answer to the question here. And the grand jury elected not to test that issue.
The thing that I was wondering about is that there is only one president, and the executive power is vested in him. And I do wonder whether or not the precedents you set with respect to other people would vest the authority in a grand jury, either on its own motion or because of what some prosecutor suggested, while the president is in office, to name him as an unindicted co-conspirator. With grand juries sitting all over the United States, and occasionally you find a politically motivated prosecutor, that's a rather far-reaching power if it exists.
It is, Mr. Justice, and there's no doubt about it. We are conscious of the delicacy of the issue. We have suggested, however, that although there is some conceivable opportunity for abuse, our judicial system, our democratic system, is based on several fundamental propositions, one of which is that grand juries usually are not malicious. Even prosecutors cannot be assumed to be malicious. We also assume, as this court regularly holds in First Amendment cases dealing with public officials, that we have a resilient society where people can be trusted to sort out truth from falsehood. We have a robust debate. I submit to you, sir, that just as in this case a grand jury would not lightly accuse the president of a crime, so too that the fear that perhaps without basis some grand jury somewhere might maliciously accuse a president of a crime is not necessarily a compelling reason for saying that a grand jury has no power to do that. I think the system may be vibrant enough to deal with that, and I think the inherent dignity of the presidential office and any incumbent provide him with a notable check against being defeated or as my colleague says, impeached by the action of a grand jury. This is perhaps the most notorious event and notorious case in recent times when the grand jury's action was disclosed. I venture to say that although it was a difficult time for all concerned, including the prosecutors as well as other counsel and the president and the country, the president has not been displaced from office. He still is president. He still functions all in accordance with his constitutional powers.
Mr. Lacovara, I wanted to get to this mechanical question that Mr. St. Clair brought up. Assume for the moment that a given tape, one of the 40-odd, 46 is it that you're asking for?
64, sir.
64, I had it transposed. One of the 64 tapes is, in fact, 1/8 of the total time, which might be several hours, apparently, because they're long tapes. That 1/8 of it involves discussions of the people who are under indictment here. But that 7/8 of it, in fact, now, you'll have to assume this, includes conferences with the secretaries of the cabinet, the joint chiefs of staff, the chairman of the Atomic Energy Commission, very high-level people, and perhaps some staff people as well. Including in those conversations some highly sensitive material. Not sensitive in the sense that it's national military secrets or diplomatic secrets, but sensitive in the sense of confidentiality. Would you not think that some mechanism ought to be available that if the participants are identified, as you've got them all identified by the voluntary submission of the President, as to the 64, that if the participants are identified and the time frame specified, that the certificate of the major persons present, that the subject was atomic energy, all sorts of other things, would be sufficient to foreclose a court from examining it in camera?
Well, to foreclose
would you think so?
The answer to my question, Mr. Chief Justice, is yes, because these are the procedures that have been set up in the Court of Appeals decision of Nixon versus Sirica, which were found to be eminently practical when the tapes subpoenaed by the grand jury were submitted. These are 6-hour reels. And under the so-called index and analysis, which the Court of Appeals in that case required to be submitted, and which Judge Sirica here has required to be submitted, counsel for the President says this is a 6-hour reel. The Watergate-related portions are minutes 312, no, that's too many, 112 through 146. Prior to that, there's a meeting between the President and the Secretary of Health, Education, and Welfare on a school bill. After the Watergate-related discussions, there's a meeting between the President and representatives of the National Association of Manufacturers. What has happened is that White House counsel has come to judges' chambers with the original reels. They have marked the beginning of the Watergate-related portions on those reels for the court to make his independent determination. This is Watergate-related and therefore offset by whatever overcoming of the privilege has been held. And after that is done, a copy of the Watergate-related portions are made. The judge does not listen to the non-Watergate-related portions, which are still covered by a presumptive executive privilege, which we have freely conceded from the time the grand jury began this process in July of '73 to our briefs in this court.
Then, as to this hypothetical 7/8, there is, you suggest, no disagreement between you and Mr. St. Clair and Mr. Jaworski and you on the one hand.
That's correct, sir. And I might say that under the procedure that was worked out, this may predate Mr. St. Clair, so you'll have to rely solely on my representation. The President indicated a willingness to allow the judge to listen to a few moments of conversation on either end of the portion of the tape that had been listed in this index and analysis as being Watergate-related, just so he would have an assurance that there was a transition from one subject to another subject. That was agreed to by the President as being, if a minimal intrusion on the confidentiality privilege for an unrelated subject, certainly by no means an excessive one.
Mr. Lacovara, I know you have only very few minutes. Are you going to address Mr. St. Clair's opening argument that the pendency of the House Judiciary impeachment inquiry either should lead the court to conclude that this whole business before us is a non-justiciable matter, and therefore necessarily that Judge Sirica's order should be quashed, or in any event, that because of the possible effect of a decision on the issue presented upon the impeachment inquiry, that the court should stay its hand?
That was to be my last point, sir, and I will make it right now. The notion that because there is concurrently underway an impeachment inquiry before the House of Representatives, that somehow makes this a non-justiciable political question is, we think, a remarkable notion which is not supported by sound constitutional law or by any of the decisions of this court. And indeed, I submit that to the extent that the court has discretion in the matter, and although this court has now been given discretionary certiorari power, district courts have no such option, it would not even be a wise exercise of discretion for this court to stay its hand. This case before the court is not a request for an opinion between two congressional committees as to who has jurisdiction over a particular bill. It's not even a request or a dispute between cabinet officers or the president and a cabinet officer over what proper executive policy ought to be. This is a criminal proceeding, a federal criminal case against 6 defendants. A subpoena has been issued to obtain evidence for use at the trial, which is scheduled to begin on September 9th. The court cannot escape the fact that this is a trial of tremendous national importance, but a trial that was brought to a head without regard to the impeachment inquiry. This is an independent, separate constitutional process that is underway. And a traditional, ordinary, prosaic remedy, a subpoena, has been utilized to obtain evidence for that trial. There's some debate about whether the evidence is critical to our prosecution. I noted in Justice Rehnquist's opinion a few weeks ago in Michigan against Tucker that he echoed, or presaged perhaps, the same point that Judge Sirica made, that it's really the obligation of the prosecution to present all of the material evidence for the jury, for the fact finder to pass upon. That's what this case involves. Now, to say that there will be public consequences, even political consequences, to the court's action does not mean this is a political question so that the court must regard it as non-justiciable. The same argument would have prevented this court from deciding Marbury and Madison. It's common knowledge that Chief Justice Marshall himself was threatened with impeachment if he decided the case against President Jefferson. He went ahead and did his duty on behalf of this court. Later, in connection with the Burr trial...
He really decided it in favor of President Jefferson, didn't he?
No, sir.
He didn't?
No, sir. He stated expressly...
He surely decided it. Jefferson won the case, the battle, but lost the war.
Well, if you...
Of judicial supremacy.
The case is normally thought of as being solely concerned with original jurisdiction. But if one reads the case again, sir, I submit, Chief Justice Marshall got to the original jurisdiction point only after he had been very decisive in saying that a lower court could issue and should issue and would be obliged to issue the mandamus to Secretary Madison because the President had no legal power to order Secretary of State Madison not to issue that commission. He held that. It might be called dictum, but it certainly in the time was a courageous act.
But the basic ruling in the case related to the original jurisdiction of the court under Article 3, did it not?
I concede that, sir. Later, however, when he did go on in 1807 to issue the subpoena to President Jefferson, That was an act of profound political consequences, but he stated again eloquently that it was the court's duty to obtain evidence if it were material to the trial. The notion that political consequences should stay the hand of the court is a notion that, again, speaking through Marshall, the court rejected in Cohen's against Virginia and the Cherokee Nation case, where it was common knowledge that the state legislatures in Virginia and Georgia would interpose themselves and defy this court. And Marshall uttered the words which I think are justly famous, that just as the court can't reach out for jurisdiction it doesn't have, it has an obligation to exercise the jurisdiction it does have, whatever may be the political consequences of that act. The court's action in Ex parte Milligan in telling President Lincoln that he did not have the power to conduct the Civil War the way he wanted to conduct it. Again, profound political consequences. Come to the war power cases in World War II, the Japanese exclusion cases. This court did not say that because of the consequences for the president or because of the political reaction to a decision one way or the other, the court should stay its hand. And Youngstown, where our colleague's brief closes by quoting Justice Frankfurter's brilliant concurring opinion, saying how the court should, as an institution, be reluctant to decide great constitutional questions. But he went on to say, we have an obligation to look into an assertion of presidential power. And even if the embarrassment to be caused to the president by our disagreeing with him would be profound, it is still the duty of the court to tell him when he's wrong. This court, in Powell against McCormick, how could there be a more political case than telling a House of Congress that it had to seat a member that it had excluded? But the court said the Constitution forbade it. It's up to the court to decide what the Constitution allows. And even though the court interprets the Constitution differently from another branch, that's the judicial process. So separation of powers here, or the notion of political question, whether something is committed to the final determination of another branch, far from supporting the president's position, demands that the court affirm the action that Judge Sirica has taken. This is emphatically the province of this court to decide. Not to belabor the point, but perhaps the finest chapter in the court's recent history has come, and finest chapters have come in the fields of reapportionment, civil rights, and the procedural rights of the criminally accused. It would be naive to say that those were not profoundly politically important decisions, but they were made as decisions of constitutional law, despite the consequences that political branches might face. Despite the public reaction, the court understood its duty to interpret the Constitution. That's all we ask for today. That's all Judge Sirica has done. We believe he has done it correctly. We believe the case is fully justiciable. We believe the principles that have been briefed by the parties support the correctness of the decision below. And we submit that this court should fully, explicitly, and decisively and definitively uphold Judge Sirica's decision.
Thank you, Mr. Lacovara. Mr. Sinclair, you have 15 minutes left.
Thank you, Mr. Chief Justice, members of the court. In response to my brother's most recent argument, of course Sawyer was an important case with political implications. Of course the other cases were, in and of themselves, important cases with political implications. But this case is different in that the decision in this case will have an undeniable impact on another proceeding. And another proceeding, which the Constitution says is essentially a political proceeding, from which the court is excluded. And for this court to be drawn into that thicket, if I may call it that, seems to me highly inappropriate, at least at this time. As I indicated at the outset, the House Committee has made certain political decisions. The President has made certain political decisions. They will each have to bear the responsibility of those decisions with the American people. This court should not impair, interfere with, or otherwise participate directly or indirectly in that proceeding. and it's inevitable that it would happen. This courtroom wouldn't be full today if this were simply a suit on a subpoena brought by the special prosecutor against the president, even though that would be an important political matter because the president is involved. But this is important for other reasons, quite apart from that. Other reasons which I suggest indicate quite clearly that this court ought to, in its discretion and in its judgment, stay its hand, at least until such time as those proceedings have run their course. Because those are political decisions being made, they should not bear the burden either way of a judicial decision.
Well, under that theory, all the criminal trials that are going on should stop then.
That would not be the first time, Mr. Justice Douglas, that a criminal trial was delayed. And in balancing the importance to this nation, I would suggest that that is clearly indicated, and I don't believe the defendants would be crying very bitter tears. But in any event, the justiciability of this case seems to me to be the single important, obvious matter that my brother would prefer not much to talk about. But there can be no doubt about it. If you read page 59 in his brief, he says, he, the President, is now the subject of an impeachment inquiry by the Committee on the Judiciary of the House of Representatives, and the subpoenaed evidence may have a material bearing on whether he is impeached, and if impeached, whether he is convicted and removed from office. And I suggest the Constitution and all of the history of the framers makes it quite clear that the framers conceived impeachment as a legislative process. The court was excluded specifically from that function. Marbury against Madison itself, I agree with the Chief Justice that it decided the case in favor of the President. The rule was discharged and the commission was not issued. But it also held, and it's been the law since that case, that the courts will not interfere with or direct a discretionary act on the part of the President or any other branch of government. And that's been confirmed in Mississippi against Johnson and any case since that time. And the discretion that the Constitution, by implication and by necessity, that has been vested in the President in determining which of his confidential communications shall be made public or released, is a discretionary act that this court ought not, by its decision, to undertake to do for him, because this court is not equipped in knowledge, background, or in any other way to exercise that discretion for the President of the United States. This is not a ministerial act. Finally, I observe a slight but significant shift in my brother's position with respect to the prima facie nature of a naming of the President as a co-conspirator. They say it can be made now that it can be made prima facie. I take it that is by examining the evidence before the grand jury in order to determine whether or not that evidence in fact supports that determination. We have invited this court and Judge Sirica to do just that. The special prosecutor has opposed in each instance this or any other court looking behind that to see whether in fact the evidence can be made, as he now states the position, to support a charge of criminality. Before the argument was that because it was a finding or a vote, it was prima facie. Now it is, I take it, somewhat different. But in any event, an action by a grand jury purporting to assess criminality to a President of the United States is a clear intrusion upon the legislative function and power with respect to impeachment. As I said earlier, the President is not above the law, nor does he contend that he is. But he does contend that as President, the law can be applied to him in only one way, and that's by impeachment, not by naming as a co-conspirator in a grand jury indictment, not by indictment or in any other way. And therefore, in this case, I urge that this court take such action as is appropriate and overrule Judge Sirica's decision and order that this case be dismissed.
Thank you, Mr. St. Clair. Thank you, Mr. Jaworski. Mr. Lacovara, the case is submitted. I have the disposition to announce for the court Number 73-1766, United States against Nixon, together with 73-1834, Nixon against the United States. We granted certiorari before judgment in these cases to review certain pretrial orders of the District Court for the District of Columbia in the case of United States against Mitchell and others. In that case, several former aides of the President were indicted by a federal grand jury for crimes including conspiracy to obstruct justice. Prosecution for the government was commenced by a special prosecutor who had been appointed by the Attorney General pursuant to federal regulation. The special prosecutor had been given broad authority. He moved for a subpoena ducis tecum to secure from the President as a third party certain specifically described material, chiefly records of various conversations between the President and others, including named defendants in pending cases. The District Court authorized the subpoena pursuant to Rule 17C of the Federal Rules of Criminal Procedure. Counsel for the President moved to quash the subpoena on the grounds, first, that the court lacked jurisdiction of the case, and second, that the courts did not have the power to review the claim of executive privilege as asserted here. The District Court, after hearing, denied the motion to quash the subpoena. The President appealed to the United States Court of Appeals for the District of Columbia Circuit, and on the same day the special prosecutor filed a petition for certiorari before judgment in this court. The grand jury, which had issued the indictment in United States against Mitchell and others, had also named the President as an unindicted co-conspirator. Shortly after the special prosecutor had filed his petition for certiorari in this court, counsel for the President filed a cross-petition for certiorari before judgment also, challenging the action of the grand jury as improper and as being unsupported by the evidence. We granted both petitions for certiorari, expedited the consideration, and heard arguments on July 8. At the outset, we should say that we conclude that the cross-petition raises an issue which it is not necessary to decide in order to resolve the issues of this case, and the cross-petition is therefore dismissed as having been improvidently granted. The President is not a party to the proceedings for which the evidence is sought. He is a third party who has in his possession or under his control material the special prosecutor claims he needs to proceed with the cases now pending in the District Court. The special prosecutor made a preliminary showing to the District Court, satisfying that court that the evidence he wanted was probably relevant to these cases and probably would be admissible. The special prosecutor was able to describe what he wanted in the subpoena ducis tecum because the daily logs and diaries which are routinely kept in the White House were supplied to him. The special prosecutor's petition to this court advised that the case for which the evidence was sought would be tried in the District Court early in September, and that he needed time to analyze the large amount of material involved. The first question to be decided is whether we have jurisdiction to review the District Court's order denying the motion to quash the subpoena. If it was a final order, it would be an appealable order. Ordinarily, an order of this kind is not regarded as final and therefore not appealable. And a party is not permitted to challenge it in an appellate court until it has become certain that the District Court will in fact command compliance on pain of contempt. There are, however, some exceptions to this, and this is one occasion for such an exception. To follow the ordinary procedure in this case would very likely produce more delay and defeat the very purpose of the rule that only final orders are appealable. For this and other reasons, we therefore conclude that this court has jurisdiction. The President's counsel contends in this case that it presents a dispute between the special prosecutor and the President, and that since both are part of the executive branch, it is an intra-branch, a jurisdictional dispute, which can be resolved only within the executive branch and not in the courts. However, the special prosecutor in this case is not an ordinary subordinate officer of the Attorney General, because by regulation of the Attorney General, the special prosecutor was given unique authority and tenure concerning specific investigations and prosecutions. His authority is to represent the United States as a sovereign, and it includes express authority to contest any privilege asserted by the executive branch. It is now well established that when the government or its departments promulgate regulations, the government is bound by those regulations even though they may be revoked or modified. But until they are revoked or until they are modified, they have the force of law. We therefore have before the court a claim by the special prosecutor vigorously contested by the President's counsel on constitutional grounds, and we hold that this presents a controversy of the kind that, as we said in Baker against Carr, provides that concrete adverseness which sharpens the presentation of issues upon which the court so largely depends for the illumination of difficult constitutional issues. Ordinarily, as we have indicated, a dispute between two officers of the executive branch is not a subject to be settled by litigation in the courts. But this case presents one of the unusual exceptions, and we therefore find no barrier to justiciability. If we were to decide that the subpoena, ducis tecum, was not properly issued in the first place, that would be the end of the matter, and no other issues would call for resolution by this court. However, from our examination of the materials submitted by the special prosecutor in support of his motion for the subpoena, we are satisfied that the district court acted within its powers under Rule 17C for the production of evidence before trial. In the performance of assigned constitutional duties, each branch of the government must initially interpret the Constitution, and the interpretation of its own powers by any one branch is due great respect from the others. The President's counsel reads the Constitution as providing an absolute privilege of confidentiality for all presidential communications. Many decisions of this court, however, have unequivocally reaffirmed the holding of Marbury against Madison in 1803, that it is emphatically the province and the duty of the judicial department to say what the law is. Our system of government requires that federal courts on occasion interpret the Constitution in a manner at variance with the construction given to that document by another branch. Any other conclusion would be contrary to the basic concept of separation of powers and the checks and balances that flow from the scheme of a tripartite government. We therefore reaffirm what was said in Marbury against Madison, that it is emphatically the province and the duty of this court to say what the law is with respect to a claim of privilege such as presented in this case. There is nothing very novel about a claim of governmental privilege asserted in litigation in federal courts. For example, in the Waterman steamship case in 1948, a case that dealt with the President's powers relating to foreign airlines, where a decision of the President had to be made in camera on confidential reports and studies relating to foreign relations, the court sustained the privilege of the President. In United States against Reynolds in 1952, claims were made against the United States for the death of various persons and the injury of others in the crash of an experimental airplane which was being tested for military uses. There, the government's claim was based on the secrecy of these very confidential and secret military instruments. In each case, Waterman and Reynolds, the claim of privilege was upheld by the courts. However, there are important differences, and only a few of them need to be mentioned here today. First, the Waterman steamship and Reynolds case were not criminal cases, and the government was not in the posture of a third party in possession of relevant evidence. Moreover, those cases, as I've noted, involved confidential military and diplomatic information. But here the claim of privilege rests simply on the generalized, undifferentiated claim of the need to keep all presidential communications private and confidential. We at once recognize the high deference that is due to protect all of the communications of a president. As early as the case of United States against Burr in 1807, Chief Justice Marshall, sitting as a trial judge, had authorized a subpoena to President Jefferson to secure certain letters in the possession of the president. And Marshall noted, among many other important passages in that opinion, that in no case of this kind would a court be required to proceed against the president as against an ordinary individual. However, the deference traditionally shown by the courts toward a president does not mean that all material in the possession of a president is immune in all circumstances from judicial process. We recognize the importance of the need to protect the confidentiality of the communication of a president with his aides and advisors. And we recognize the risk that publication of those communications may well have an adverse effect upon the ability of a president to secure candid advice and opposing views on important questions. However, no case of this court has extended this high degree of deference to a president's generalized need of confidentiality. Nowhere in the Constitution is there any explicit reference to the privilege of confidentiality, yet to the extent this interest relates to the effective discharge of a president's powers, it is constitutionally based. In this case, we must weigh the importance of the general privilege of confidentiality of presidential communications in the performance of his responsibilities against the inroads of such a privilege on the fair administration of criminal justice. Although the interest in preserving confidentiality is, as we have noted, very weighty indeed and entitled to great respect, we cannot conclude that advisors will be moved to temper the candor of their remarks by the infrequent occasions of disclosure that may be brought about because of the possibility that such conversations will be called for in the context of a criminal prosecution. On the other hand, the allowance of the privilege to withhold evidence that is demonstrably relevant in a criminal trial would cut deeply into the guarantee of due process of law and gravely impair the basic function of the courts under Article 3. A president's acknowledged need for confidentiality in the communications of his office is general in nature, whereas the constitutional need for the production of relevant evidence in a criminal proceeding is specific and central to the fair adjudication of a particular criminal case in the administration of justice. Without access to specific facts, a criminal prosecution may be totally frustrated. The President's broad interest in confidentiality of communications will not, in our view, be vitiated by disclosure of a limited number of conversations which have preliminarily been shown to have some bearing on a pending criminal case. We conclude, therefore, that when the ground for asserting the privilege as to subpoenaed materials sought for the use in a criminal trial is based solely on the generalized interest in confidentiality, as distinguished from the situations where it may be based upon military secrets or diplomatic secrets, it cannot prevail over the fundamental demands of due process of law in the fair administration of criminal justice. The generalized assertion of privilege must yield to the demonstrated specific need for the evidence in a pending criminal trial. Accordingly, the judgment under review is affirmed. Mr. Justice Rehnquist took no part in the consideration or decision of these cases.